Lord, my apologies. Lord, initially, Lord, when the matters were heard, there were 3 issues identified for the purpose of stay.
That's not
Because
true.
prayer is praying stay of the statute. Lord, I have filed my affidavit mentioning specifically that in view of the discussion which took place, I am filing this reply for the 3 issues. But the written submissions have come, which deals with, my Lord, many other provisions also. My request would be, my Lord, that kindly confine it to the 3 issues as already identified.
Well, I'm sorry, Malat. This is entirely, I'm sorry to say, my great regard for my learned friend, Malat. Matter was listed earlier, then it came up later saying, the judge saying that I will, the then Chief Justice said, I will hear the matter and see what further interim orders are to be passed.
No,
That's how the
Lord,
matter
all of
came
us
up.
were there.
I don't want, Malat,
All of us
we
were
have,
there.
we have made our submissions. We gave them in time to him. Malat, those matters are already in the petition, Malat. My learned friend can't say that I will only argue on 3 issues, Malat. I'm going to argue on the issues, Malat, that are, in fact, most important in the case, because this is a case of capture of the entire Waqf properties. That's what it is. But Malaz, I'm going to argue on all the issues. My learned friend can't say. He can.
Well, Lordships cannot be asked to have a piecemeal hearing. The Lordships really cannot be asked to have a piecemeal hearing.
Hear it on this.
Substantive issues.
Hearing only on the question of grant of interest.
Correct. That's also broadly, Malaz. I tell your lordship that.
On 3 points I have said, my Lord, contemporaneously in my affidavit in reply, para 4, that at the outset it is respectfully submitted.
Where is that order? Where is that order?
But if you say that.
Only a minute, Mr. Sibal.
No, but you are saying there's an order of the court. The
Please
court said
allow,
that.
this is not disputed. It is stated on affidavit
His statement was
by an
limited.
officer who was present in the court, filing a prelim only to deal with the issues flagged during the earlier hearing on 16th April 25.
We were there, Malaz.
This is contemporaneously filed, contemporaneously reported everywhere. I leave it to your lordship. I wanted to flag this. This may not be fair to the court,
Because
and fair to the.
neither of us is party to those. We are not aware of what happened.
There was no truncation of issues.
There is none, Malaz. In fact, the order said
No
we
dispute.
clarify. We clarify that the hearing fixed on the next date will be a preliminary hearing, and if required, interim orders will be passed.
Let's
This has
read,
nothing
my
to
lord,
do
the
with
first
issues.
order. Let's
Limiting
read the
of it.
first order. My lord, the first order which Mr. Sibal is reading, 17th April
Yes, yes,
25.
yes.
Yes, I'm reading that.
Please do.
Lord, please see. Your lordship, say, my lord. I'll, my lord. Please.
Let him say what he has to say.
Lord, can I read, my lord? I'll just read, my lord, and leave it at that, my lord. This can't be the, not that we don't have answer to other questions, but this would be unfair to the court and unfair to the other side. During the course of the hearing, Mr. So-and-so, that is myself, stated that respondent would like to file a response within a period of 7 days from today. He assures this court that till the next date of hearing, no appointments would be made to the Central Waqf Council and Waqf boards. That was the first issue flagged, section 9 and section 14 respectively. Then I'm skipping because that's section 19, 14, etc. is mentioned. It is also stated that till the next date of hearing, no Waqf, including a Waqf by user, whether declared by way of notification or by way of registration, shall be denotified. But this is pertaining to section 3R, where we have deleted the Waqf by user prospectively from hereafter. We take these statements on record, rejoinder to be filed. Thereafter, the court directs that 5 will be the lead petitions. And it was 7 days because, it was 3 issues, and thereafter, the court at the end said, we clarified that the hearing fixed on the next date will be a preliminary hearing, and if required, interim orders will be passed.
That's all.
This is what, all of us were present.
So were
The
we.
court had flagged these issues, but I don't wish to embarrass the bench. It would be unfair, that's all I'm saying.
Can we go into that? Because if you are saying, all of us are saying that it was decided, they will deny it and we can't go
The
now.
denial would be unfortunate, but I
In
don't
fact, the
want to.
statement is unfortunate, not the denial.
And we can't go and ask or other
No, sir.
creditors.
I don't wish, your lordship.
We will have to go by whatever is the record.
Yes, my lord, but I have said on affidavit that since these three issues were flagged, my reply is confined to three issues.
My lords, what happened was in the
And there is no
hearing,
denial in
my
the
learned
rejoinder.
friend will realize what happened was the court came and the court said, look, give me an answer on these three. The court did not say, and that's why the court later said, you please argue the whole matter, and that's why it was fixed for interim orders.
Afternoon
That
hearing,
was an
time was
afternoon. Well, we-
brought. It's not that there were truncation of issues like this. This was done. It was then for continuation, in fact, for extending the order on other points, either way. Not any limitation. of-
Anyway, as it is, we have paucity of time. Let's go on with the matter.
Plus, today the written submission is as virtually reading, arguing the entire writ petition itself.
Yes.
With all due respect.
Mr.
When the reply is confined only to three issues, plus their written submission.
We have given them 2 hours. They have to decide as to how they will.
That's why we want to start and let's
Yes.
finish. Mullahs, in
But
2
I
hours.
just flagged it and leave it at that. my
We
lord.
can't go into that inquiry.
I understand.
We can't ask the running judges. as to-
It's unfortunate, but I leave it at that.
Normally, we go by whatever is there in the black and white in the order sheet.
Yes, my lord, we sometimes trust, my lord, the other side will not
Come
take
on,
us
I mean,
understand.
No, that's an unfortunate
For the-
statement to make.
I don't know why.
That's an
Let's,
unfortunate.
Anyway.
Mr. Mehta,
I leave it to, my lord, let them argue.
I'm feeling happy that I have only 6 more months left here.
We are not happy, my
So
lord.
my experience of 18 years in the High Court,
Lord, we have-
compared to the 6 years here, has been much better.
My lord, that I can also say, my lord, for High Court, my lord, because I have also come from High Court, so is my learned friend.
but those practices are not being followed here, Mullahs, despite the fact that people come from the High Court.
Yes, my lord. So we learn wrong things, my lord, from our seniors.
That's the problem.
Yes.
Anyway, Mullahs, I think
Then let's proceed, yes.
let's proceed. Now, Mullahs, kindly just leave your paper book for the moment. I'll tell your lordships what the contours of my submission are. Mullahs, this is a case in which the 2025 Act has been framed, Mullahs, for the purposes of protection of Waqfs. But in reality, it is designed to capture Waqfs through a process which is non-judicial, through a process which is executive, through a process in which those to whom this property belongs, because Waqf can't be created without, except through private properties owned by the individual concerned. So private properties are being taken away only because there is some dispute. We don't know what the nature of the dispute is. And when that dispute happens, Mullahs, a person is appointed who is higher than the collector, and that person will decide the dispute on his own. He will give a report, but by the time, Mullahs, that report is given, we don't have the time frame. And within that, Mullahs, while that report is pending, the Waqf property is taken away. And
Taken away without following due process?
yes, and without following any procedure. I'll demonstrate all that to your lordships. Taken away with the Mullahs, the dispute is whether this is government property or my property. He will decide that. He is a nominee of the government, Mullahs, who is higher than the collector. So the government decides its own dispute without any judicial procedure. And while that dispute is pending, while that report is pending, the property is taken away. It is no longer Waqf property. And there is no procedure. And anybody can create a dispute. So this is one aspect of the matter, which is in the context of what I say, it was designed to take over and capture Waqf properties. That's number one. Number two, Mullahs, what is a Waqf? A Waqf, Mullahs, is a endowment to Allah, to God. A dedication to Allah, to God. And that, pursuant to that dedication, that property can't be dealt with in terms of transfer. You can't transfer that property to anybody. Once a Waqf is always a Waqf. That's the very concept of a Waqf, Mullahs. In other words, if I have, Mullahs, in fact, dedicated my piece of property, because I cannot dedicate somebody else's piece of property. And the historical reason behind it, let me just tell your lordships that, is that, as your lordship knows, under our constitution, Mullahs, the state cannot possibly finance religious institutions. Cannot finance, Mullahs. If there's a mosque, Mullahs, the state cannot finance it for its upkeep. If, Mullahs, there is a burial ground, this has to be created through private property. So what happens is, mothers, that people at the end of their lives, mothers, give their private property dedicated to God, so that those who come later, mothers, can take advantage of that property. There are no earnings there, mothers. If you go to a burial ground, mothers, nobody earns. People come to bury their dead bodies, mothers, and they charge a certain amount through which they maintain that. If you go to a mosque, mothers, there's not a chadhava, mothers, like in temples. They don't have 1,000 crores, 2,000 crores, 3,000 crores, mullahs. There are no charavas in mosque. So those have to be maintained. And how are they going to be maintained? Through the kind of monies that we collect through processes, mullahs, of charity. That's all.
That happens in other religions also. When temples are...
No, but temples, mullahs, people give, as your lordship knows, mullahs, they are charavas that are given, mullahs, and temples are, in terms of mullahs,
But even in the...
mosque.
I visit dargahs also, I visit churches also, everybody...
Dargahs and mosques Dargahs and mosques are different. Dargahs and mosques are I'm talking about a mosque, Mullahs. Your lordship is right. On dargah, it's different. But I'm talking about mosques. So what I was trying to say was, Mullahs, the ways to preserve these properties is through these kind of efforts that are made by the community. Right? Now, Mullahs, what they say is that if anybody, supposing an encroacher creates a dispute, that property will lose its character as Waqf property as long as the dispute is pending. This is what the Act says. So you have a situation, Mullahs, where actually there was a Waqf Act. You just note this, Mullahs. There was a Waqf Act of 2013.
2013.
2013. 19, huh? Will you allow me? 2013, then, 1913, 1923, 1913, 1923.
What's in 1923?
1913, 1913, then 1923, then
1913, 1913. 1913.
1913, then 1923, then 1954, then 1984, then 1995, then 2013 and 2025. This is, Mullahs, the history of it. Yes.
Just factually, 84 and 2013 are amendments, not the...
No, I'm talking about the Act.
Yes.
Correct? So, Mullahs, therefore, and I will demonstrate to your lordships that the 2025 Act is a complete departure from the past. I tell your lordships how. There are two concepts in law called Waqf by user and a dedication which is made. Right. If you give a dedication, Mullahs, and you pass away, and that property is used, Mullahs, for the purposes of the dedication, it becomes a Waqf by user. And it's perpetuity. That's the concept of Waqf. Once a Waqf, always a Waqf. Correct, Mullahs? Now that Waqf by user has been done away. A concept that is recognized in the Babri Masjid case, saying Waqf by user is a practice, a religious practice, that has continued for hundreds of years. That's the five-judge bench, Mullahs. And whether it's a Waqf by user or not is a matter of evidence. But they've done away with it. How have they done away with it? They say that in the 1913 Act, the 1923 Act, the 1954 Act, and the later acts, there was a requirement for registration. And because you did not register, Mullahs, therefore, any Waqf which is not registered will not be regarded as Waqf. So many of these Waqfs by users were created 100 years ago, 50 years ago, 200 years ago, Mullahs, 500 years ago. Where will you get them?
Is it a matter of fact that under those enactments, 1913, 1923, and so on, is there a requirement for registration?
There was.
So is it a mandatory or?
They shall be registered, they said. But the consequences of non-registration were not set up in the Act. The consequences of non-registration, this is the first time in the 2025. Telling your lordships what my submissions are going to be.
I've not gone through. I'll be frank, so you'll have to start from ABCD.
Yes.
Just as a matter of information as whether under the old act,
Yes.
the provision was for registration was mandatory or directly?
The expression used was shall.
Merely using shall may not make it mandatory.
Correct.
Were there any consequences provided in those acts for non-registration? If consequences are provided, then it will be mandatory. Whether word shall is used or not.
No, the consequences were not that it will not be regarded as a waqf. That was never the consequence.
Was there anything that on account of registration of a particular?
You won't be regarded as a, no,
something will happen.
no, there's no consequence that you will not be regarded as a waqf. It will continue as a waqf.
But there were consequences.
No, not this consequence.
No, but
No,
there were
no,
For
other
the caretaker, there may be consequences, but not this.
We will record your submission.
Yes, please.
That though under the old act, there were requirements for registration, but they were not mandatory because the consequences for non-registration were not provided under those acts.
For the purposes of deciding.
On account of non-registration,
Yes,
nothing was to be happened.
yes,
Like suppose if there is under certain act, mandatory duty is there. You have to do such and such thing within a particular period.
correct.
And if you don't do that, then you will be required to pay 1,000 rupees fine or 1 lakh rupees fine. So no such provision is there.
No. The only thing was, Malaz, that the act said that the mutawalli who has not done it is made culpable. That's all. He loses his right to continue as a mutawalli.
That's all. There
So
was,
that's all. As I said to your lordship, and I stand by that, there were no consequences provided that it will no longer be regarded as waqf.
no,
Which is
no other consequences were there.
no other consequences. Which is why the 2025 takes that away.
So
Therefore, it's a complete departure.
so do we record that?
Yes, your lordship may record. It's a complete departure from the
No, that
19
under 2013, sorry, 1913. Till order, the last one, 1913 till 2013.
till 2013. The status of the waqf,
2013,
yeah,
though,
the status and character of the waqf.
no, though
continue.
there was a provision
Yes,
for registration of
yes,
a work.
yes.
No consequences were provided.
Right.
Were provided for non-compliance,
Right.
except removal of a mutawalli.
Correct, because he is responsible for registration of the waqf.
So there, except removal of a mutawalli,
Yes. Consequences qua the mutawalli.
not a trust, not a work.
Correct. Well, that's for the community, Malat. So because he did not register, he will suffer the consequences, but the character of the waqf will not change and cannot. This changes it. I'm just giving you lordship broadly. This changes the character of the waqf. It says if you're not registered under these acts, then you're no longer waqf. That's number one. Number two, if you are a waqf by user, you must tell us as to who is the one who established the waqf. Well, how do we know? If it is established 200 years ago, how will anybody tell you today who established it? Because there was no registration at that point in time. They were user. That is why waqf by user is a matter of evidence held by the Constitution bench of this court.
1913 to 2013.
Yes. Well, 23 was the first one actually.
Whether during 1913 to 2013,
Yeah.
registration was not necessary insofar as work by user is concerned.
Yes. They have now removed it completely.
Was it permissible under the?
Yes. Throughout, Manoj. Otherwise, I wouldn't be making this submission. Works by user, this is established practice recognized by
Yeah, so
the Constitution bench of this court.
second submission is that prior to 2025, work by user was not required to be registered.
What happened was, Manoj, in 1954, for the first time, there was a requirement of registration as such. Otherwise, 23. Yes. मैं कह रहा हूँ यार तुम बता रहे हो गलत बोल रहे हो।
2020.
Your Lordship may say prior to 1923 or prior to after 1954, Malats, what happened was when the British were here, they didn't want to interfere in the practices, religious practices, control provisions or management provisions, Malats, in those acts. But in 1954, it became mandatory that you must register. Now, who was to register? The Muttawalli. The Muttawalli was not
Prior to 1954,
Yes.
the registration of work by user was not necessary.
No, nobody was questioning Waqf by user ever. Till date, Malats, nobody is questioning except this act, except the 2025 act.
Probably you have not understood the question. What we are only asking you, was it mandatory or required to be registered as a Waqf under the acts prevalent at that relevant time as a Waqf?
After
Maybe by
1954,
Waqf
yes.
by user.
After 1954, yes.
Yes. So
Yes.
after 1954.
Yes.
The registration was mandated.
Mandatory.
And it had
Even insofar as work by user is concerned.
Yes. Even by Waqf by user. All works had to be registered. Muttawalli had to register them. If he did not register them, then consequences followed way here.
on the Muttawalli.
But
we'll see into
the
that.
Waqf property did not lose its character as Waqf. That's the point.
So according to you, prior to 1954,
Yes.
registration of work by user was not necessary and it became necessary after 1954. Was not necessary.
2025.
I'm saying that, but these fellows are either saying 23 or
Only after 1954 it became necessary.
Yes.
Only after 1954 it.
Malaj, there is some confusion on this, maybe after 1923. Your Lordship may write 1923 because.
Okay.
Yeah.
So we'll write,
Say 1923, Malaj, not
we
1954.
are recording everything so that we can call upon them to answer all.
1923 because I've read the act myself. That's why I was saying 1923. 23, Malaj.
Problem is that so
So
much of pressure
yes.
not only builds pressure on us but also on you.
Yeah, exactly, Malaj. I got different discordant voices here.
23.
So therefore we are
Yes, just I show you that the 23 Act says within 6 months from the commencement.
first
Yeah.
first we'll record your proposition
Yes.
so that
Yes, so that we know, Malaj, what.
It's not to disturb Mr. Sibal, Malad. He's continuously being disturbed from all.
That's all right. Don't worry about it. I'll take care of it.
Yes. You must.
he is trying his best. We can see it in a better manner.
Yes, Malad. Others may not disturb.
We can see it in a better manner. He has tried at least half a dozen times.
So therefore, that's the proposition. Let's make it 23, not
Okay,
54.
23. After 23 it was necessary.
Yes, necessary. But no consequences square the dedication.
So that we already recorded.
Yes. So, Malaj, that's the second proposition. You take away Waqf by user. Third proposition is, Malaj, just note two dates, 1904 and 1958. These acts relate to Ancient Monuments and Archaeological Sites and Remains Act of 1958. And there is the 1904 Act, which is also here, which is the Ancient Monuments Preservation Act of 1904.
Ancient Monument.
Preservation Act 1904. So two acts, 1904 and 1958, both dealing with ancient monuments.
Both 1904 as well as 50.
And 1958. So, Malaj, when this 1904 Act came, Malaj, as your Lordship knows, Waqfs were there. The
The works were from centuries we are saying that there.
Waqfs have been there, Malaj. So what the Act did not interfere. For example, Malaj, you have, say, the Jama Masjid, or any other places of worship. It's a waqf, but it's getting dilapidated, right? So the government can say, we want to preserve this property. We want to make sure it doesn't get dilapidated. And therefore, they give a notification saying that for the purposes of preserving the property, it is declared as an ancient monument, right? But it doesn't lose its character. It doesn't mean that you can't go and pray there.
So, though it is preserved as an ancient monument, but
no ownership was transferred to the government. And it doesn't, you couldn't stop the user of the Waqf property for the purposes of the dedication. You couldn't change the identity either.
like in Khajuraho,
Correct.
there is an
Exactly.
ancient temple
Correct.
where, though it is in the custody of the
Exactly.
archaeology department,
Correct.
being a heritage structure, still the people can go and pray.
Exactly. Exactly. So, Mullahs, now the 2025 Act says, moment it's declared or it has been declared as an ancient monument, is no longer a Waqf. That's why I said it's a complete taking over of Waqf properties of a community. Complete takeover, including ownership. Before or after?
No, but does it take away your right to practice your religious
Yes,
practices?
yes. I will demonstrate to the declaration itself is void.
Are you stopped from going and praying there?
Yes, declaration of the Waqf is void. Yes, that's the third proposition.
Fourth.
Yeah.
Sorry, third.
Yeah.
On such declaration,
Yes.
as a
On or before,
on
Madam.
such declaration as an ancient monument.
Yes. As a protected monument
Okay.
or protected area.
So, Mr. Singh, we would appreciate if there is only one voice from one side. It has been difficult for me to,
Area under the
for last 6 years to, but then,
No, it says Ancient Monuments Preservation Act 1904.
so on such
Ancient monuments,
declaration as a protected monument.
yes. Or protected area.
Protected area.
Under the Ancient Monuments Preservation Act and Ancient Monuments and Archaeological Sites Act of 1958, at the time of such declaration.
Under the
and-
State Act.
Yes. Yeah, and it should, Waqf property shall be void.
No, but does it also take away your right to go and practice?
Once
religious
the
practice?
Waqf is void, Mullah, I can't go there. The Waqf itself, it becomes void. That's what the section says. Any declaration or notification issued under this act or under any previous act in respect of Waqf property shall be void if such property is as a protected monument or protected area. So once it is void, Mullah, how can I possibly go and...
Like, with Khajura, I know because I had visited recently. It's all with, now under the custody of archaeology department because all those structures are heritage structures. But still there is a temple wherein all devotees can go and
Yes.
pray.
Yes.
So therefore, I'm asking whether this declaration would also take away your right of going there and praying, offering prayers and all that.
Well, the problem is,
Maybe because it will be declared cease to be work because the maintenance and everything of a heritage structure is on a different yardsticks.
but if the Waqf is void itself, that means it's no longer a Waqf. And it's not my right anymore, Mullah. When you say Waqf is void, it's no longer a Waqf.
But is it your also? Is it your also contention that on such declaration,
Yeah.
all religious practices which were being undertaken earlier would also not be permitted?
Mullah, it's my case that this provision is violative of 25, Article 25 of the
So should we
Constitution.
record that?
Yes, please. It's
What will be
expropriatory.
void
Yes,
and the right of the citizens
yes,
to continue with their religious practices.
that's correct. Article 25 and 26.
Their religious practices will be taken away.
taken away. Therefore, it is expropriatory.
Mr. Mehta, you can ask someone to record all this.
But I am recording it. It's factually incorrect in my.
We are not asking you, we are not
I am
asking.
recording. I am recording.
You argue when your turn comes.
Yes, I argue when my turn comes. I am recording.
We are only asking because since we are recording, we will be calling upon you to answer this thing.
Obviously, I have to answer.
The rights of the citizens to continue with their religious practice. The protected area. The Waqf
Monument,
will be-
monument or
yeah,
area.
the Waqf will be void,
Yes.
and the right of the citizens to continue with their religious practices will be jeopardized, and therefore violative of Article 25.
25, 26 and 14, Malat, because how do you declare something to be void, because the perpetuity of the dedication is lost.
Article 14, 25 and 26.
Yes, I'm good.
Yes.
Because only Muslims are there.
Yes, sir, I know, only Muslims, of course.
So
Don't want-
you should have invited all of them for dinner yesterday, and so that, that would have been better. Now everybody is advising you here.
I forgot that.
Well, that's the other important thing that your lordships will know. This is a corollary to this proposition, is that under the Ancient Monuments Act and these two acts, my right to religious worship was preserved,
So that,
despite its declaration. Under the acts themselves, it was preserved.
and now it has been taken away.
And now it is taken away.
Under the said act,
No, it was preserved.
right to religious practices preserved.
Yes.
Yes.
Right? I mean, it says that a protected monument maintained by the central government under this act, which is a place of worship or shrine, shall not be used for any purpose inconsistent with its character. It was preserved, taken away.
16.
That's 3D, Malas.
6.
Sorry, 1 second.
Section 3D.
This is the present 2025 section is 3D. D, capital D. Next proposition, Malas. That I have to be a practicing Muslim for 5 years before I can create a waqf. So, Malas, at 77,
One has to
Right.
be a practicing.
Muslim for 5 years before I can create a waqf. So who will decide that? I guess they will come home and ask
Could be
me.
section
3R.
3R,
3R.
yes,
R capital or
small R, Malas. So, Malas, I have to ask whom? And if I am on my deathbed, I'll have to say, and I want to create a waqf and dedicate it to God, then I'll have to demonstrate to them that I'm a practicing Muslim. I mean, it's per se unconstitutional, per se. It's my right under 25. It's my right under 26. And you take that away through a definition of this nature. Then, Mullahs, you have scheduled tribes in tribal areas, Mullahs, where Muslims are scheduled tribes.
Yes.
Correct? They say in those areas, these properties will be declared not to be waqf properties. That's 3 capital E. No land belonging to members of the scheduled tribes under the provisions of the 5th schedule or 6th schedule shall be declared or deemed to be waqf properties. On what
old
basis?
ones also go, according to you.
Yes, everything goes.
Assuming there is one work and registered, that also is.
Yes, absolutely. Shall be declared or deemed to be waqf property. I'll come to that. No, this is just the proposition. Right? So therefore, 3E is per se unconstitutional.
3E.
Yes.
What is your proposition so that we can record it?
3E, Mullahs, sets out states
You
that
tell us your proposition.
the proposition is that if a scheduled tribe Malads, who are Muslims, they have Waqf property and they are practicing Malads, or willing to create Waqf, then that Waqf is deemed to be, not deemed to be Waqf property at all. So therefore, that's also expropriation on the face of it. And their right under 25 is taken away.
Will be deemed not to be.
Waqf property. And cannot be declared as Waqf property. And we've given a schedule of all the of the tribes mullahs of Muslim population. We've given a list. We'll give.
This is according to you, by virtue of this, all works created earlier
Yes.
of
Even,
properties
yes,
come to
everything
SP and SP. Will also be.
Everything goes.
Muslims, that is his case.
I'm not saying, I said scheduled tribes. Did I say anything else?
Muslims.
I said scheduled tribes.
Yes.
That's what the section says. According to us, per se unconstitutional.
The fifth and sixth schedule area.
Then, Malads, the next one is the right of management of Waqf properties has been taken away. Because the Central Waqf Council members of the Central Waqf Council, majority of the members of the Central Waqf Council are non-Muslims, maybe non-Muslims.
Because majority of
The members of the Waqf Council may be non-Muslims. It's 12, 8,
of the
under this it is. There is section 9, Malads, related to,
council
yes, Central Waqf Council.
would be non-Muslim.
Majority can be non-Muslims.
Can be or would be.
It can be Malads. That means they will have a majority if they choose to nominate Malads.
Can be non-Muslims.
Yes. And on the calculation, it is 12 non-Muslims and 8 Muslims. Not sorry? And 10, sorry, 12 and 10, not 8.
12
And
non-Muslims.
12 non-Muslims, 10 Muslims. And nominated. And then section 14 also, Malads, relates to
This is section.
14, relates to the composition of the board.
But this council is.
This is 9. This is section 9. 14 is for the board,
And 23 for the CEO.
composition of the board. Earlier, Malads, the board members were elected under the previous act. And they were all Muslims. And now, Malads, it's fully,
Elected by whom?
and now it's elected by the various organizations through which they came. I'll just show to your lordships that. Electoral colleges, Malads, of Muslims. They elected members, they were all Muslims. Now they're all nominated.
In the boards,
Yes, on the board, all nominated.
but in this Central Waqf Council also.
Yes. Those were also nominated under the previous acts. But they were Muslims. There the majority was 12 to 10, as I told your lordships. Here they are all nominated.
In the board.
Yes, all nominated. And it will be 7 to 11. 7 will be maximum, will be non-Muslims. 11 will be non-Muslims.
11
It will be total,
7 can be.
11 total, 7 can be non-Muslims. But all nominated. So the electoral college process has been done away. So they were, in a way, they conceptually capture the waqfs. They expropriate the property.
Out of 11, 7
Can be non-Muslims.
can be.
Yes. And all nominated. So, Mullah, that itself is violative of 25 and 26. Your Lordship knows management has to be done by the community.
Well, also the CEO.
Yes.
CEO.
Yes. And then section 23, the CEO is to be appointed by the state government.
CEO of the,
CEO of the board shall be appointed by the state government who actually runs the board. And he'll also be a non-Muslim. Earlier Muslim, now non-Muslim. So the government will, in fact,
It's not mentioned non-Muslim. I think it should.
no, it just says nominee of the state government.
That's right, only nominee. It
Yes.
can even be a Muslim. That's for them.
Earlier it said Muslim, has to be Muslim.
There was specifically.
Yes,
required.
that's why I'm saying, Manas. It's an absolute departure. Original said there shall be a full-time executive officer who shall be a Muslim. Therefore, Manas, all I'm giving your lordships is that this has nothing to do with all the legislations that happened earlier. This is an absolute departure and an attempt to take over through creeping acquisition Waqf properties.
This
And
is the section
This is 23.
23, Manas.
23.
23. So broadly, Malats, broadly, these are the issues. Right? That out for the moment. There are other issues, Malats, but what is this?
today we are
Only,
for the interim relief.
that's right, that's right. Now, Malats, now,
The presumption is with regard to the constitutionality.
that's correct.
And normally the court should not
Correct,
say the,
correct, absolutely.
so unless you make out a very, very
Strong case.
glaring case.
Yes, correct. And your lordships have done it in the past, so I won't go into that at the moment. Now, let's kindly have a look at the act now. I'll demonstrate each
We are
one.
not saying we are powerless, but then the case which has to be made out.
Absolutely, absolutely. Which is why I'm trying, Manoj. Which is why I'm trying.
Otherwise, the presumption is with regard to
Of course.
constitutionality of a statute.
But what
That's the law which we have been taught from the colleges.
the problem is you have to decide it on
And,
the basis.
And in the light of the present.
Lordships need not say anything more.
I won't say anything more.
Well, therefore, we have to make a prima facie case, which is what I'm trying to do. We have to demonstrate to your lordships the balance of convenience in our favor, and irreparable injury will be done if these provisions are activated. That's what we have to demonstrate. So if I can't create a Waqf unless I demonstrate 5 years of being a Muslim, and if that is operated, it's an immediate injury, it cannot be. It's irreparable. If a government officer above the rank of a collector is to decide a dispute between the government and the Waqf mullahs without reference to any judicial procedure, it is irreversible. The question may come from anywhere.
So there's a finality to the
Yes.
decision of that officer.
Yes, fine. No time period, finality. I just now, mullahs, let me just now.
Finality to the decision of the collector.
Well, what happens is under section 3C, if there is a dispute to a government property or a property of a government organization, supposing the district collector or the government feels that this is our property, let's assume, then an officer is designated above the rank of a collector, right, Mullah? He will then give a report. The time frame for that report is not set out. While he is contemplating to give a report, the nature of that property as Waqf is done away with.
So even before that report is
Yes,
there.
even that report is fine.
Shall not be treated as.
It shall not be treated as Waqf. So this is irreparable.
So this is under section.
3C, 3 capital C. Proviso.
Under section
3 capital C proviso.
the,
Capital C
what is
proviso.
called designated officer.
Yes, designated officer above the rank of a collector. It says that he'll conduct an inquiry, quote, unquote, as per law, no law, whether this is government property or not, and that property shall not be treated as Waqf property till the designated officer submits a report. So therefore, before the inquiry,
So designated officer, when he conducts an inquiry,
yes,
so during pendency of inquiry, that property can be taken away.
it is no longer Waqf property. It can't be treated as Waqf.
The moment the inquiry is initiated,
Yes, it can't be treated as Waqf.
for all intents and purposes,
Yes.
it ceases to be a,
Ceases to be a Waqf
without any declaration.
without even an inquiry, because he's yet to have the inquiry. He's yet to conduct an inquiry. And there's no adjudicatory process there.
Work property.
There's no
So
adjudicatory.
without, even if somebody raises a dispute,
Anybody.
Yeah, anybody can raise a dispute.
he well was, we know that we know your enthusiasm. Give him benefit of his experience of more than 50, 60 years at the bar. You can be comfortable if some chair is available, otherwise you'll ask them to provide.
Take seat.
Sit down.
During pendency of the inquiry, it will cease to be a work,
Yes.
and everybody would be stopped from continuing their practice.
Absolutely.
Or whether they are also entitled to take away the possession during the pendency of the inquiry.
Nobody says no longer a Waqf, that's the end of the matter. It's not be treated as a Waqf. So how do I exercise my rights under 25, 26?
So the citizens cannot exercise their rights of religious practice.
Let's not go into that. Now, once he submits a report, normally the procedure in law is not prescribed under 3C as to what inquiry is to be conducted. He doesn't have to go to a tribunal. He doesn't have to go to...
There's a finality to his decision.
There's a finality. Once he submits the report, the revenue records will be amended accordingly for him. And the board will be given a direction that you also correct your records that this is no longer Waqf property. That's the consequence. I will. I'm just hold on.
Revenue record and board records will be required.
Yes, will be required to be amended. And this is without any judicial process at all. Now, what's more interesting, and this connects to Mullad's a very important argument, that under 83 of the 2025 Act,
But one will. Under
Section 83 of the 2025 Act deals with constitution of tribunals.
section
83.
83.
Yes. Now, what happens is that once under 3C, it is no longer a Waqf, then I become the aggrieved party. Only I can go to the tribunal. Government is not required to go to the tribunal to find out whether it's Waqf or not. So through an executive process, you decide on what the nature of that property is. You don't go to a judicial process, and then you force the Waqif or the person aggrieved to go to the tribunal and say that, no, this decision of the collector was wrong. Now that will take 5 years, 10 years, 15 years, and even if it comes in my favor, the nature of the property is gone. The most egregious provision, it's inconsistent with 14.
Is required to
Yes.
go to the tribunal.
Yes. He doesn't have to go. So now, let me just read the provisions to support this.
During the proceeding under section 83,
Yes,
the status of the property is already changed. That is it taken away by the government?
correct. And I have to go to the tribunal to demonstrate.
Status of the property is changed.
Under 3C, it's already changed.
Okay. And the Waqif also loses possession.
Yes. Then whoever aggrieved, whichever is the aggrieved party.
So the Waqif will also lose possession of the property.
Naturally. Yes. Because before the inquiry starts, it's no longer Waqf. Now, let's kindly have a look at the definition of Waqf in 3R. Just take the act now, Millards. The amended.
I.
R, Millards.
So now, as compared to Learned Solicitors' 3 propositions, they become 10 now.
But he'll have 11 solutions for that. Never 3, Millards, but anyway, be that as it may. So may I just read the definition with their lordship's permission, Millards? Waqf means the permanent dedication by any person showing or demonstrating that he is practicing Islam for the last 5 years. Lordship has that? Page 7 of this book. Lordship sees that? Lordship has that? May I read it? It says, Waqf means the permanent dedication of any person showing or demonstrating that he is a practicing Islam for the last at least 5 years, of any movable or immovable property, having ownership of such property, and that there is no contrivance involved in the dedication of such property for any purpose recognized by the Muslim law as pious, religious, or charitable. So I don't know what this means. I have to demonstrate that there is no contrivance involved in the dedication of the property. So that's, according to me, Millards, on the face of it, unconstitutional. Why should I have to show them that I'm a practicing Muslim? And to whom am I to show that? And what inquiry is to take place? Who is going to decide that matter? In what manner will they decide that I'm not a practicing Muslim or I'm a practicing Muslim? And why should I have to wait for 5 years? On the face of it, Millards, it's violative of 14. And it's directly violative of 25 and 26. Leave it there. It's time. Show them later. Yes. Now, Millards, kindly see, immediately after this, over the page, you small I, your lordship sees. Millards, just sees small I on the top of page 8 of this book.
Yes, I is deleted.
It's deleted, Millards, your lordship sees that? Kindly go to the footnote. Kindly go. What was it in the earlier act, Millards? Prior to omission, stood as under a waqf by user, but such waqf shall not cease to be a waqf by reason only of the user having ceased irrespective of the period of such cessor. Removed. Waqf by user removed. That's why I've been saying it's capturing waqf property throughout the country. Creeping acquisition of waqf properties throughout the country. Through executive fiat.
Not all. It is only limited to one category. You may say so.
No, I'll show the others also.
That's a different
Yes.
matter. But as of now, it
As
is
of
with regard
yes,
to one category.
only one category.
Whatever you are saying would be relevant as far as the
Yes,
one category.
fair enough, fair enough, fair enough, fair enough.
A work by user, but such work shall not cease to be work by reason only of the user having ceased irrespective of
Period of such.
So, in addition to this, there are other grounds.
Yes, I'm going to show.
Even under the earlier act,
Yes.
it could cease to be a work. Only by reason of non-user, it could not.
No, it never ceased to be a waqf by user. Never. Because it's a dedication to God, Millards. There's no question of it ever ceasing. Because somebody else will use that property. But it can't be transferred. Kindly, Millards, this is the whole difference between waqf as a concept, Millards, and trust as a concept. Waqf is a dedication to God. And therefore the community will use it in whatever manner. If you have a place, a small place where people come and rest, a little small rest house, Millards. Now, if the person ceases to exist,
Musafir Khana.
yeah, Musafir Khana, that's a waqf. No, it can't cease to be that. This was the provision that protected it. They took it away. Now come to the proviso. Provided that the existing waqf by user properties registered on or before the commencement of this act. So now, Mullahs, you are now ensuring that only waqf by user which are registered are the ones that will remain. Page 8 middle. Provided that the existing waqf by user properties registered on or before the commencement of the Waqf Amendment Act as waqf by user will remain as waqf properties except that the property wholly or in part is in dispute or is a government property. So, Mullahs, if any third person raises a dispute, for example, Mullahs, an encroacher raises a dispute, it will not be waqf property.
Last one, after they're abolished.
Can you see, Mullahs? And Mullahs, government property means what? Government property is defined. Now see, Mullahs, that definition in section 3, small fa and fb, page 6 of the statute. Kindly read 3FB first. Government property, page 6. Government property means movable or immovable property or any part thereof belonging to a government organization. Right, Mullahs? Then government organization is defined in 3FA, just above this. A government organization includes the central government, state governments, municipalities, panchayats, attached and subordinate offices, autonomous bodies of the central government, state government, any organization or institution owned and controlled by the central government or state government. So, Mullahs, in fact, every organization is covered under this act. A panchayat is covered. So, if a panchayat raises a dispute, that's the end of the waqf. I just read that proviso to your lordships. Any dispute, local panchayat, municipality.
But will it automatically cease to be a work property?
It is. I'll show you 3C, Mullahs. That hones into 3C, capital C. Now just read 3C with me after having seen this. Then I'll come back to Mullahs section 3B.
So
Just come to 3C after this.
so according to you, in view of proviso, to 3R,
Yes.
if any dispute is raised, the same work property will cease to be work property.
Yes. And it's quay, Mullahs, any local authority or any dispute raised by anybody. Yeah, even a company controlled, Mullahs. So now kindly see. And Mullahs, in 3R you have is in dispute or is government property. So it may not, dispute may not relate to government property at all.
But maybe between
It's a private person.
two individuals. So
Exactly. Then also it ceases to be waqf. By virtue of the statute, Mullahs.
At Aurangabad, there are so many disputes with regard to work property.
Correct. It's in our DNA, Mullahs. Yeah. And it says wholly or in part. Well, let's just see what is the submission. Waqf by user abolished. 3R deals with registered waqf by user. Registered waqf by user, if there's a dispute, waqf goes. That dispute may be with a private party or with the government. If it is government, the designated offerer will decide under 3C. He starts an inquiry. Before the inquiry is no longer waqf. So in effect, you are expropriating all the waqf property.
What about a dispute within a private property?
That also no longer waqf. What are you trying to do? Any private party will raise a dispute. We see that happening every day, Malas. So any private party will raise a dispute. It will no longer be above. What are you trying to do? You are actually throttling.
So is it relatable to any particular nature of dispute?
No, no.
Simple dispute.
Just simple. It doesn't define.
Doing a lessee.
Relate to that property only.
Whatever.
Relate to that property only. That's correct.
That would also include.
Yes.
That may not be. It would relatable to the.
But it's not Malas, clarified. Your Lordship is right, but it's not clarified, Malas.
Answer, you are saying that he has 11 answers, so maybe 12.
Now, Malas, kindly read 3C, Malas, capital C. That's at page 9. It says any government property, now government property now defined as government organization and all local bodies. They're all government property. All companies identified or declared as waqf property before or after the commencement of act shall not be deemed to be waqf property. If any question arises as to whether any such property is a government property, the state government may by notification designate an officer above the rank of collector, as I mentioned to your lordships, hereinafter referred to as the designated officer, who shall conduct an inquiry as per law. Now, which is that law, Malas? Doesn't go to the tribunal, because only the aggrieved party will go to the tribunal under 83. We don't know what this law is. There is no procedure set out. And determine whether such property is government property or not, and submit his report to the state government. So he's a government officer. Dispute is between government and the waqf. He will decide the dispute without any procedure. He'll be a judge in his own cause, and proviso, provided that such property shall not be treated as waqf property till designated officer submits his report. Which is what I was indicating to your lordships at the outset, as a proposition. Yes, it's a determination. Yes. Subsection 3 says, in case the designated officer determines the property to be government property, he shall make necessary corrections in revenue record and submit a report in this regard to the state government, which is what I told your lordships. And the state government under subsection 4 shall, on receipt of the report of the designated officer, direct the board to make appropriate corrections in the records. Now then, who is then the aggrieved party? Us, the waqf. Then under 83, I go to the tribunal. So a dispute which is judicial in nature, decided through the executive, after being a judge in his own cause, and before the inquiry starts, this is no longer a waqf. After the inquiry is over, the revenue records are corrected, and I have to go to the tribunal for an adjudication, and God alone how long that will take. And in the meantime, my right is taken away. It's expropriatory. It's violative of 25. It's violative of 14. It's manifestly unjust and arbitrary. So that's that one point, Mullah, which I placed before your lords. Now, let's kindly come back to 3B. And this 3C applies to all forms of waqf, not just waqf by user, all forms of waqf. the moment this dispute is created. Now kindly come to 3B, Malaj. Which is perhaps even more problematic. 3 capital B at page 8. May I read it, Malaj? Every Waqf registered under this Act prior to the commencement of the Waqf Amendment Act 2025 shall file the details of the Waqf and the property dedicated to the Waqf on the portal and database within a period of 6 months from commencement. Right, Malaj? Now kindly come to subsection 2. What are those details that have to be provided? The details of the Waqf under subsection 1, amongst other information, shall include the following. Kindly come to B. The name and address of the creator of the Waqf, mode and date of such creation. How will people have that, Mullah? In a Waqf by user. Waqf created 200 years ago. How do we know who the creator of the Waqf is? What is the date of creation?
Can never have a creator. Waqf by user can never have a creator. By definition, it cannot.
That's exactly the point. That's why, precisely the point. This is about the registered work we are talking about. Because even after registration, a Waqf by user can be registered, Mullah, he still may not know. And if I don't give it, Mullah, I can go to jail for, the Matwalli will go to jail for 6 months. Read it with 61(1)(a). Because it deals with every Waqf registered, Mullah. It may be a Waqf by user or otherwise. It applies to every Waqf registered. Kindly come to page 51, Mullah. Section 61. Page 50, section 61. If a mutawalli fails to, and kindly straight away come to Roman small 5 at page 51, upload the details of Waqf under 3B. Those are the details I mentioned to your lordships. Now what will happen to him? He shall be punishable with imprisonment for a term which may extend to 6 months and also with fine. So if he doesn't know the name of the creator, Malats, he shall suffer imprisonment. Now kindly note, kindly note, let's go back to 3B2. Instead of B, kindly read C. He has to also produce the deed of Waqf. But after that, correct, but it doesn't apply to B. It doesn't, it should have been. Because, Malaz, if he doesn't give the name of the creator and the date, he will be imprisoned. It would have been better worded if available was also there. Correct, correct. Right, so Malaz, I have taken care of 3C and 3B, and also the proposition that I have to wait for 5 years as a Muslim. So those 3 I have taken care of. Now issued under this Act or under any provisions, any previous Act in respect of Waqf properties shall be void. This is what I was trying to show to your Lordship when I made that proposition. If such property was a protected monument or protected area under the Ancient Monuments Preservation Act 1904 or the Ancient Monuments and Archaeological Sites and Remains Act 1958 at the time of such declaration or notification. Taj Mahal is a protected monument. Under the Ancient Monuments and Archaeological Sites. At the time of such declaration or notification. At the time. So it is retrospective. So this section operates retrospectively because many of these monuments were declared as ancient monuments even prior to independence. So retrospectively, they lose all their character. Quite frankly, I haven't ever seen an act so generous to a community as this one is. Yes. Correct. 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 Now kindly see, Malak, kindly come to the Ancient Monuments and Archaeological Sites Act. No, let's go to the 1904 Act first. Ancient Monuments Preservation Act 1904. That's in this book itself, Malak, which your Lordship has. And your Lordship will find it at page 54. A 1904 Act is part of the 1958 Act. Malak. Now, just kindly have a look at the definition, Malak, of ancient monument at page 55. It starts at page 54, the 1904 Act.
It is United Work Management Empowerment.
No. In the same book. In the same book at the end, you will have that. Oh. Ancient Monument book, your Lordship is to have.
Ancient Monument Act.
Yeah, I'm sorry, yes. If it's the 2000, I have the 2022 edition.
Yes, sir.
Then it will be page 54. Your Lordship has the 22 edition? Yeah, then the page is 54. Well, this will give you an indication that the intent was never to interfere in rights of minorities under 25. The definition itself. Ancient monuments, that's at page 55. Preamble says, an act to provide for the preservation of ancient monuments and objects of archaeological, historical, or artistic interest. Preservation, that's the intent. Ancient monument means any structure, erection, or monument, or any tumulus or place of interment, or any cave, rock sculpture, inscription, or monolith, which is of historical, archaeological, or artistic interest, or any remains thereof, and includes site of an ancient monument, such portion of land adjoining it, which may require fencing or covering in, or otherwise preserving such monument, means of access to and convenient inspection of ancient monument. So your Lordship notices here, it doesn't have any religious tone to it. A religious structure can also be an ancient monument, but the intent is to preserve it. But what they've done in 3 declaration, then it ceases to be a waqf. And the waqf is void. And retrospectively, how do you defend something like this? And then, Millet, kindly come to page, page 58, section 10. Yeah, come to 6 first, Millet. All right. Kindly see section 4 first, ancient monuments. Page 56. The collector, with the sanction of the central government, may purchase or take a lease of any protected monument. Collector, with the like sanction, may accept a gift or bequest of a protected monument. The owner of any protected monument may, by written instrument, constitute the commissioner the guardian of the monument. And when the commissioner accepts the guardianship of the monument, owner shall accept, as expressly provided in the Act, have the same estate, right, title, and interest in or to the monument, as if the commissioner had not been constituted guardian thereof. Whereas the fundamental theme, as far as the waqf is concerned, is that it is my property. I cannot create a waqf unless it is my property. And this my property is taken away through a legislative diktat. In other words, a person's property is acquired without
Section 6.
section 4, Mullahs, I was showing to your lordships. Declarations are under section 3 or protected monument. 4 says that, look, it can be purchased, it can be taken on lease. 5 says there has to be an agreement for preservation. I don't want to read all of it, Mullahs, because there's not enough time. It's only prima facie. And then section 10 says compulsory purchase of ancient monument if the central government apprehends that a protected monument is in danger of being destroyed, injured, or allowed to fall into decay. The central government may direct the state government to acquire it. This is not the case. Here, pursuant to a declaration, the acquisition takes place. And the waqf is void. And says the powers of compulsory purchase conferred under 1 shall not be exercised in the case of any monument which or any part of which is periodically used for religious observance, or any monument which is the subject matter of subsisting agreement executed under 5. So the intent of the Act is to preserve my right. 2025 destroys it, takes it away, expropriates it, and through a diktat. And the definition itself, but it's actually talk of a religious construction. Now kindly see, Mullahs. Let's go to the other Act now. Now kindly see the 58 Act. At page, Mullahs, 3 of this book. Now, if your lordship looked. Yes. All these declarations, Mullahs, were made in 1904 and continued in 1958. And they are giving them retrospective effect, take away the waqf character. Now kindly see, Mullahs, the definition itself at page 3 is the same as in the 1904 Act. So I won't read it, Mullahs. It has no religious color to it. And then, Mullahs, kindly come to section 5 at page 7. It's the same, Mullahs. It is exactly the same as in the 1904 Act, section 4. Acquisition of rights in a protected monument, exactly the same. And it says subsection 6, just note that, Mullahs, at page 7, nothing in this section shall affect the use of any protected monument for customary religious observances. So the intent of both these acts was never to take over, Mullahs, the rights of a minority community for religious purposes, using this property for religious purposes. Never the intent. But the 2025 is a complete departure. And then kindly come to section 13. Yeah, yeah. Mullahs, you may have a protected monument. Mullahs, actually, there are many of these which have nothing to do with religious purposes also. So it may be dilapidated. The owner may be, he says, I can't really keep up the maintenance of this protected monument. So under 6, they can have mullahs an agreement. That's the spirit of the act. And then section 13 is acquisition. It is the same one. The definition is almost the same. Yes. Now, let's kindly see 13. If the central government apprehends that a protected monument is in danger of being destroyed, injured, misused, or allowed to fall into decay, it may acquire the protected monument under the provisions of the Land Acquisition Act. The intent was never to take away property. Otherwise, this provision would never be there. Because as I said, Mullah, the underlying purpose of a trust, of a waqf, is that I create a waqf through my ownership of that property. So if I'm taking away somebody's ownership, even if you were to acquire it, you'll have to give compensation under the Land Acquisition Act. Now again, through legislative diktat, they've done away with this. So it's violation of 300A, it's a violation of 14, it's a violation of 25 and 26, per se. And section 24 is identical, 20 is power to acquire protected areas. The same thing as Muller's protected monuments is in 13 and protected areas are 20. And kindly now see 16, very important section. This is at page 10. A protected monument maintained by the central government under this act, which is a place of worship or shrine, shall not be used for any purpose inconsistent with its character. So these statutes preserve the character of either the ancient monument or the protected area. And you have now destroyed that character by directly encroaching upon the minorities' rights under 25. There has to be a legislative rationale which must be evident by reading the provisions of the Act. I'll continue it. One second.
But
Not too much time, but my learned friends may also give.
I would also like.
Yes. Not too much time.
Support while not repeating anything you say.
that everybody says. But always in breach.
In his case, it's the proof of the pudding is in the eating, Mullah. He always deeply obsessed. कर दूंगा.
Your Lordship's kind permission, my lords, if I may take the liberty of mentioning item 25, my lords. There was some urgency here. These are medical candidates who've completed their MBBS course, but they are not getting their certificates. They are missing their PG courses and they're not able to get their license to practice. If, my lord, I understand that today it might not reach. So, my lords, if, my lord, in the next 2-3 days, my lords, if,
Next week we'll direct it to police.
my lords, if possible, if Friday is possible,
Monday, Tuesday, next.
my lord, then Monday. Please make it Monday. Obliged.
Well, a similar request.
That's my matter, God. I'm the petitioner. Friday.
My lord, then Friday, if my,
You can't start your vacation so soon.
Please go by whatever your lordship declares. Put the side others.
my lord, please make it.
Tuesday,
No,
I was saying Friday, if it's possible.
Friday, yes.
yes, my lord, if your lordships then.
how you can't start your vacation because we don't know what will be.
My lord, just a 5-7 minutes on Friday, my lord. We will.
You know, we have 5-7 minutes.
This is not. Where fees not 1 year was fixed 1150, then 850, then again
No,
1150.
that, my lord, we will correct that.
50
It's
students
not-
want to remain, not pay the difference.
Not, that is not correct.
They're going to take time. This is not a matter.
No, my lords, we will, because we are going to show that whether even if we do not succeed, my lord, they have excess with them and they are denying us even our
You
internship,
are appearing for whom?
the medical college.
Not for medical college. Yeah, for the students.
So we are for the medical students.
Friday.
Most obliged.
Well, a similar request in item 26. This is the challenge, Milos, to NEET PG 2025 exam, Milos, where they are conducting 2 exams for Milos, in 2 shifts. We had challenged that. Your Lordship had kept it specifically for today. Your Lordship have it tomorrow or day after, Milos. The process is at a very advanced
Thursday, Friday.
Thursday.
Your Lordships, may I kindly please mention item number 32, Millets. Parties in this matter, Millets, had settlement and the settlement had been placed on record by the mediator, Millets. Now, the only aspect that the terms have been complied under the settlement, Millets, the amount which was directed to be deposited with the registry, Millets, may kindly be released in favor of the respondent.
Take a day after.
Day after tomorrow, Millets. Great.
Just one clarification. Originally, when I said, Malaj, that the requirement was registration only in 54, I was right. Actually, 1923 Act doesn't have a requirement of registration. There was an order of the court in that case saying that all Waqf properties give a list to us and we will put them up. But the Act didn't have any requirement. So you also may change that from 23 to 54 months.
What you said, 54 was right.
Yes.
Because of.
What is that, sir? We always doubt ourselves when somebody says you may be wrong. So, yeah.
We are all human beings, can happen.
You know, we're all fallible.
Yes.
There's one interesting thing that I wish to point out. Just have a look at this, please. Can you give it to the board? Give it to the other side also. It's very interesting. Yeah, just take it. Now, this is a list taken by us from the ASI website, Mulaj. And you lordships will see now, the moment they are protected monuments, they lose their character as Waqf. So this includes Sambal Mulaj, item 3 Mulaj. Jama Masjid Sambal. There's a matter pending, declaration made, and the Waqf character goes. So legislation, in a sense, resolves a judicial dispute pending. That's the extent of the impact of this. And this is not the entire list, Mullahs. We only got some. And we've given the serial numbers, Mullahs, in the ASI list itself. Very disturbing.
Yes.
Number 2, Mullahs, just wanted to point out that 3D as the section was not circulated in the bill. The bill didn't have 3D. It was introduced in Parliament during the voting. It wasn't even before JPC. 3D and 3E. 3D and 3E. Not in the original bill circulated. No discussion, no time for discussion. Not even in the JPC, naturally, because if it's not in the bill, where would it be in the JPC? So these are very disturbing features, Malaj, that...
Even in Parliament, there was no discussion.
I'm sorry?
Even in Parliament, there was no discussion on 3D and 3E.
No, it was just when the final bill was passed, they introduced the amendment without debate. Passed. Suspending the rules, inserted 3D and passed. Because your lordship knows the speaker and can suspend the rules. So introduce 3D, introduce 3E, get it passed because you have majority.
At the time of voting, it was introduced and passed.
Yeah, naturally, at the time of voting, you suspend the rules, you introduce this just before the voting. It can't be during voting, just before the voting. Yes. The question is that, of course, we can never challenge the legislation on the basis of malafide, as your lordship has held it time and again, Malaj. But these are very disturbing features which ought to be taken note of, Malaj. Of course, ultimately in the final hearing, your lordships will hear us on this. But that's number one. The suspension of rule, Malaj, page number 102. Just note that, Malaj, in writ petition 276 of 2025.
Writ petition number?
226 of 2020, 276 of 2025. First matter, Maulana Arshad Madani. 276 of 2025. At page 102.
Kindly record his statement that 3D was not discussed in JPC. Nothing turns on that, but kindly record it.
Yes, we have recorded this. Therefore, we are recording each and every proposition.
I am saying on instructions, Malaj.
Section 3D and 3 not circulated in the original bill. No discussion, no time for discussion either in JPC or in Parliament.
It's correct.
I'll answer, my lord, whether that can affect the validity of a
No,
legislation.
that's a separate
But
issue.
factually, kindly, my lord.
I'm not saying whether it affects or doesn't. No, I know that, but there is no, in the JPC, 3D is not circulated. I know that. 3D is not circulated.
And now it depends.
Nor is 3E circulated. Now, may I just kindly see 102. May I just read it? Or is the lead petition, page 102. What is the date of this?
Yes.
Now, kindly see, Malaj, the law minister says that this house do suspend. I of 80. My lord has that? Yes. In page 102. Justice Masi.
Sorry.
I'm sorry, Your Honor. So this house do suspend clause I of 80 of the rules of procedure and conduct of business insofar as it requires that an amendment shall be within the scope of the bill and relevant to the subject matter of the clause to which it relates in its application to. Now just note it, Malaj, and they suspend it, and then note the date, Malaj. Wide amendments number list number 11 circulated on 2/4. Lordships have that date? And this is cleared on 2/4. Suspended, circulated on 2/4, cleared on 2/4.
No notice to anybody.
This amendment may be allowed or moved.
You give me a copy.
Yeah, I will give you. No, it's in the petition, page 102. It's page 102. Anyway, just what the impact of that is, we'll see later. Now, let's just one other thing. Kindly come to 1995 Act for a minute. Just give it the 1995 Act. Yeah. Yes. Now just see that, 2025 Act the losses may take. I know. Amended by 2025. Yeah. Then if you look at the 95 Act, just look at section 4, Malaj. Survey. So that's what you want to show. Show the survey. 1995 Act, survey. So previously, Malaj, the regime was, there used to be a survey. And after the survey, Malaj, the items identified had to be registered.
After survey?
The items identified, that is the Waqf identified, would have to be registered. There was a very, very, very elaborate procedure. Your Lordships will have it in the footnote of the 2025 Act. Preliminary survey of Waqf is removed, Malaj. And if you look at the 95 Act, you will find that there's a whole survey provision. Your Lordships have the 95 Act or no?
Yes, we have.
The unamended one.
Unamended we don't have.
Yeah, just give it to my lords.
But then the footnote there is there prior to substitution.
Yeah, but what did the survey procedure involve, Malaj? I'm just mentioning that to you. His Lordships have it, no? Now, so therefore, what happens is, page Malaj 6, section 4. So you have to have a preliminary survey of Waqf. The state government, Malaj, by notification appoints a survey commissioner. Then other commissioners are appointed for the purposes of making the survey. Then every state government maintains a list, and the survey of Waqf shall be completed within a period of 1 year from the commencement of the Waqf Amendment Act of 2013. And if it's not done, Malaj, then provided that where no survey commissioner has been appointed, a survey commissioner shall be appointed. And then under subsection 3, there's a whole inquiry process. Survey commissioner, after making an inquiry, as he may consider necessary, submit his report. And what is that inquiry? Nature of objects of the Waqf, number of Waqfs, gross income, amount of land revenue, expenses incurred. So there's a whole very, very elaborate procedure. That's all I want to show to your Lordships. Now the survey commissioner is over. It's now replaced by the designated officer. The collector now. That's all, the whole process is over. Right? And then let's to section 5, publication of list. So once the survey is done, section 5 of the 95 Act says that list will be published. Yes. And none of this relates to registration. This is to find out what are the Waqf properties in various parts of the country. And then 5.2 will say the board shall examine the report and forward it back to the government within a period of 6 months. And then 5.3 says the revenue authority shall include the list of Waqf while updating the land records. So there's a whole very, very elaborate process. Then comes, Malaj, section 36 of this very act. Thereafter, the registration is done. Yeah, then 37. Any question, any confused with that? It's always better for them to look at the Leave it to me, I have some experience. जब लिखते हैं
Section 36 of 95 Act.
Yes, of the 95 Act. So there's a survey procedure, then there's a list that is prepared, and then the registration happens, which is under 36. 36 says every Waqf, page 27, whether created before or after the commencement, shall be registered at the office of the board.
Registration is not introduced for the first time in this act.
No. It's been there for a long time. I told your lordship, right from 54. It's just the consequence is only quay the mutawalli. And earlier also surveys were done. Survey was introduced in 64, Malas. Registration was in 54. Survey was introduced in 64. And that's constantly been happening, Malas, under every subsequent act, Malas, we amended. Then, Malas, the decision if a property is Waqf property. Then, Malas, the board itself, section 40. So whatever is surveyed will be registered. For what is left out, the board itself can collect information. And that's section 40. This also removed. Survey removed. Registration requirement remains. 40 removed. If the board has reason to believe that property, if any, arises whether a particular property is Waqf property or not.
You're reading?
That's 40, section 40. And the board was given the power to decide that question on its own. Why? Because the board were consisted of Muslims and elected. And they could call for information and decide if it's left out anywhere. So that was the regime, Malas. Now that's all done away with. Now the power is with the collector. So collector will, what surveys will the collector do, Malas? No, 37. 7A. Yes, I will. Now let's connect this to section 36, 7A of the present act, of the 2025 Act. So that survey provision goes, Malas. And 36(1) says, every Waqf, whether created before or after the commencement, shall be registered at the office of the board. That's 36. So, Malas, and then, Malas, subsection 7 says the following. At page 34. So, it shall be registered. And on receipt of an application for registration, the board should forward the application to the collector. So your lordship knows then, Malas, that the survey and all is over.
You're reading section?
Section 36, 1 and 7 of the amended act.
It's amended.
Yes, Malas. So 36(1) talks about registration, no? Every Waqf, whether created before or after, shall be registered. And then 7 says at page 34, Malas, on receipt of an application for registration, the board shall forward the application to the collector, having jurisdiction to inquire into the genuineness and validity of the application and correctness of the particulars therein, and submit a report to the board. So, Malas, all the survey procedure is just given a go-by to. Then, Malas, 7A. Yeah. It's all being recorded in any case. 7A says where the collector in his report mentions that the property wholly or in part is in dispute. Now let's connect this to 3R and 3C. Connect this to 3R and 3C. Can be any dispute raised by anybody. So where the collector in his report mentions that the property wholly or in part is in dispute or is a government property, the Waqf in relation to such property shall not be registered. So if somebody says this is disputed, even if I want to register it, I can't. This is what is called wholesale takeover, Malads, of a community's right. Wholesale takeover. I'm going to. Really. 8. Subsection 8, I'm sorry, Ms. Justice Massey has that. It says, in the case of Waqf created before the commencement of this Act, every application for registration shall be made within 3 months from such commencement, and in case created after such commencement, within 3 months of the date of creation. And then 10, Malads, which is very, very problematic. No suit, appeal, or other legal proceeding for the enforcement of any right on behalf of any Waqf which has not been registered in accordance with the provisions of this Act shall be instituted or commenced or heard, tried or decided by any court after expiry of the period of 6 months. So you don't register me, then I can go nowhere. I can't file a suit, I can't file any proceedings. So my fundamental right to litigate is lost. My property is taken over and I can't litigate on that property. And this is through legislative fiat without a procedure. Nothing can be more violative of 14, Malad, manifestly arbitrary. So now connected to the 83 provision. Designated officer under 3C, higher than the collector. If he says it's in dispute, it's government property. Right, Malaj? Then that dispute, Malaj, takes away the character of the Waqf as long as the dispute is pending and his report is pending. And after that, it goes to the revenue records. And then I have to go to the tribunal. But if it's not allowed to be registered, I can't even go to the tribunal. Because no suit, no proceeding shall lie. And connect it to 3R then, because 3C deals with government property and government organizations, panchayats and all. 3R says any dispute. So the consequences of this act are take over the property of Waqfs, take over the community's property, and then don't allow them a remedy also. And by the time the aggrieved party in a particular case goes to the tribunal, then 10 years will pass, and that's the end of the matter. So therefore, valuable property across the country where for charitable purposes, religious purposes, mothers is just taken away. The perpetuity of the Waqf is lost. And the fundamental of Waqf is...
But then, whether this provision, even under the earlier acts, the registration was compulsory.
Yes. Yes. This provision was not there, Malaj.
No. So whatever properties are registered prior to the commencement of this act.
It was there. It was not implemented.
So, we requested you in the beginning itself.
Sorry, my lord, but it's...
We requested in the beginning that we will...
Something troubling, my lord. Anyway, I'll point out when my turn comes.
Thank you. Yes, Malaj, your lordship was saying something.
No, earlier the next was also provided for registration.
Yes.
All such works which are registered prior to this commencement of this act, they would not be affected by this provision. Only such of the trusts which were required to be registered but have not been registered, they have been given a breather of 3 months.
No, but if there is a dispute, Malaj, then that's the problem. Your Lordship is right. But supposing there's a dispute, then what happens?
3D is a retrospective.
3C,
Yes.
And E.
that makes it a problematic for us. R, 3R, 3C makes it problematic for user. I'm going to read that.
We have 3 members. So that's, there is also an onus on the state government to conduct a survey. If the government has failed to conduct this survey, then why should the community pay for it?
Right.
This image registers the again to submit the details.
This tradition is kind of
Waqf by user is abolished. So, whether Waqf by user done away with? On the registration part, your Lordship knows registration is required to give the name and address of the creator. I don't do that, no registration. If no registration, no remedy. Where registered Waqfs? I'm talking about registered Waqfs now. Your Lordship asked me that question. If registration is done prior, then I have to give this detail, name and address of creator of Waqf. If I can't do that, not registered. Not registered means the 7A and 10 will come in. And the collector will say this property is in dispute. Apart from that, because 7A says property in dispute. So if property is in dispute, it will not be registered. If not registered, then section 10, subsection 10 comes in. So, where's the remedy? So you can't, put the community in a slot, enslave it, don't allow them any leeway, take away their property, don't compensate because it's private property, it's not public property, it's my property, don't allow them a procedure to vindicate my rights. You don't have to go to the tribunal, that I have to go to the tribunal. Until kingdom come, that matter will not be decided. And I guess I'm being facetious. The same thing is now 3E. Now I've done with 3D, I've done with the others. Now just come to 3E, Mullahs. Same thing happened as far as 3 is concerned in the parliament. 3E and 3D both. Now, Mullahs, I've given to your lordships my submissions.
It's a spiral bound note which I gave, Lord. It's in your lordship's note. This can
I'm not going to read them, Mullahs, because I've argued all that already. So I just want to show you an annexure. My written note. Kindly see page 18.
Of your note.
Of my written submissions, Mullahs, which has all that I have argued before your lordships is there.
So you want to refer to the spiral one or the
spiral one.
Spiral.
Nothing is the same.
I don't have annexed. I'm not making an issue.
Just give me annexed.
Sure, give it to me. It's there, Mullahs. Page 18. It's part of the submissions.
Responded to this. He has already responded.
No, not this. Oh, you got it without it.
Copy. I'm not raising an issue.
No. Fine. We have another copy. Not an issue. I'm sorry if that's not happened. Kindly see 18, Mullahs. These are the list of scheduled tribes with Muslim population. I just wanted to point that out because that's what's reflected in 3E. In various states, Mullahs, I've set out the states also.
Schedule 5 to 1.
Mullahs, most of the submissions I'm not going to other provisions of the Act because that will require further elaboration. These are per se violations, per se. Now read 3E, Millet, and I've done with 3. Just I'll have to read the section. That's at page 10 of your Lordship's book. Notwithstanding anything contained in this Act or any other law for the time being in force, no land belonging to, sorry, Millet, 3E, page 10 of the Act, Millet, 2025, as amended. Notwithstanding anything contained in this Act or any other law for the time being in force, no land belonging to members of scheduled tribes under the provisions of the 5th and the 6th schedule shall be declared or deemed to be Waqf property. So I've shown you the list, Millet, so they lose their status as Waqf.
In the 5th schedule
And the 6th schedule. This is per se bad. Then kindly come to section 108. No, wait. Kindly come to 108. Now, this is an interesting provision. 108 deals with evacuee property, a gift from partition millers. Page 79 of the statute that your Lordship has. Now, Now, 108 Malas provision is omitted in this Act, which is, we have a look at the footnote, Malas, what it was. This is in the 2013 Act. The provisions of this Act, sorry, Malas, I'm sorry, it's a footnote. The provisions of this Act at page 79 shall apply and shall be deemed always to have applied in relation to any evacuee property within the meaning of Clause F of 2 of the Administration of Evacuee Property Act, which immediately before it became such evacuee property within the said meaning was property comprised in any waqf, and in particular any entrustment, whether by transfer or any documents or in any other manner, and whether generally or for the specified purpose, of any such property to a board made before the commencement of this Act, in pursuance of instructions of the custodian under the Administration of Evacuee Property Act, shall have and shall be deemed always to have had, notwithstanding anything contained in any other provision, effect as if such instrument had operated and vested in such board. So all evacuee property, which is a gift of partition, vested with the board. So now all evacuee property, which is waqf property, waqf, once a waqf, always a waqf, is taken over by the government. Now, Malaj.
Sorry, Chair is the.
No, I won't.
I didn't get your point on this.
Malaj, 108 is eliminated. It's still evacuee property. It's waqf property, Malaj, but it's evacuee property. It was waqf, people left. It continued to be waqf property. Once a waqf, always a waqf. So in 108, Malaj, it says that that property, which was always a waqf, would be given to the board. Instead of the administrator, would be given to the board. Why? Because it's waqf property and the board has to administer it. Then 3C will come in.
That may be so.
Yes.
The thing is, it was mandated to be registered.
Yes.
Obviously, if it is registered, then it continues to be a waqf. How does it go back to the
evacuee property, Malaj, no, it will not be.
No, it would.
It will go to the custodian.
Every waqf had to be registered.
Right.
So if it is a waqf, it had to be registered.
I appreciate what my lord is saying, but every evacuee property by law goes to the custodian for allocation.
Not relatable to the waqf. As such, the principle is it goes back to the custodian.
Yes. Now, if it's waqf, the custodian will not keep it.
Will keep it. Will go to the board.
That's all that I'm saying. I'm saying nothing more than that. It will go.
Even if it goes back to the board, continues with the board in any case.
That's what we are saying, but it will not happen now.
But in any
Because
case, if it
3C
is-
will come in.
But any property which is not registered, obviously as a consequence of section 3.
Yes,
Uh,
that's right.
no more be a work. That's your contention.
That's my contention.
You have to hear.
You have to go back to, ultimately we have to go back to 3C. We have to go to 3R. We have to go to Muller's inquiry. All that will come in Muller's. So basically, these are all interconnected provisions, the object of which is to take over Waqf properties. That's the object. And through legislative fiat, without a procedure consistent with the law. Well, it's not somebody else's property. That's really the heart of the matter. So, Mullahs, now I've done with all this. There are only two things left now, Section 9 and Section 14.
And 23.
CEO, you've already mentioned. That's not mentioned. Yeah, I already mentioned CEO. Now, Mullahs, now Section 9 and Section 14. Yes. And then I have done, Mullahs. Now, Mullahs, I mentioned to your lordships that Section 9, if we read it now, that's at page 16, will have a majority, can have a majority of non-Muslims. I know. Yeah. Just 95 Act provision, there were all Muslims. I sure now, yeah, sure.
Yeah, right.
Yeah, well, now let's kindly come to Section 9 and kindly look at the Section 9 as it was under the 1995 Act. And you will find in the footnote, Mullahs, the following members to be appointed from amongst Muslims. You see that at page 17 bottom. Last line at page 16, bottom, Mullahs, prior to substitution, subsection 2 stood thus. Worship has that? Right at the bottom, Mullahs.
The
Right.
council shall consist of.
Yes, prior to substitution. Right at the bottom in the footnote. That is the previous Section 9, Mullahs. I'm just showing, Mullahs, what the change is. Prior to substitution, sub-rule 2 stood as the council shall consist of union minister, following members to be appointed by the central government from amongst Muslims, namely, all of them were to be Muslims, 3 persons who are eminent scholars in Muslim law, provided that at least 2 of the members appointed under subclause 1 to 7 shall be women. That's it. So, Mullahs, all of them had to be Muslim?
Judges. Even judges. Even members of parliament and judges.
Even members of parliament and judges had to be Muslim under the previous dispensation. It is true also of all the Hindu endowments, Mullahs. They all have to be Hindu, Mullahs. I've given that in my note also. Now, Mullahs, if you look at the present section, which your lordships will find at 17 top, union minister in charge of Waqf, no reference to Muslim. 3 members of parliament, of whom 2 shall be from the House of the People and Council of States, no reference to Muslim. The following members to be appointed by the central government from amongst Muslim members. So 3 persons to represent Muslim organizations, chairperson of 3 boards, that is 3 by rotation, so therefore 3 and 1, 4. 1 person to represent Mutawalli, that is 5. 3 persons who are eminent scholars in Muslim law, 8. Correct, Malaj? So the total number of Muslim members are 8. D is 2 judges of the Supreme Court or High Court. So therefore 2 there. 1 advocate of national evidence, that's 3. 4 persons of national evidence, that's 7. Additional secretary or joint secretary, that's 8. And Mullah, the first 3, union chairperson and 3 members of parliament, 12. So it's 12 versus 7. So you can have 12 non-Muslims in a situation and 7 Muslims. And the previous acts are all Muslims. So in other words, the administration also is taken over. Proviso says only about 2 members of, excluding that, shall be non-Muslims. So that's the ex officio members. That's right. They provided further that 2 members appointed under this subsection, excluding ex officio members, shall be non-Muslims. At least 2 and up to 12. At least 2 and up to 12.
So it doesn't say at least, provided further that 2 members
appointed under this subsection, excluding ex officio members.
Shall be non-Muslim.
That's correct. Excluding ex officio members. So union minister is ex officio. Other may or may not be.
But then how do you say that there would be majority?
Because we are here, we are 10 only, 7.
So ex officio would be 1.
Only 1.
So the union minister can be both, either a Muslim.
No, it's excluding ex officio members, it says.
Yes.
Shall be non-Muslim. So it will exclude the minister.
Union minister in charge of the work is ex officio.
Yes, he's excluded, he'll be non-Muslim.
Yeah.
Then 3 members of parliament.
So the other ex officio is only additional secretary or joint secretary.
That's correct. They'll be non-Muslims, they say. At least 2 of them says, no? Provided.
There is only 1.
No.
Additional secretary or joint secretary.
Above 3 members of parliament also, Mullah.
They are not ex officio.
No, correct. Correct.
They are not ex officio.
But there is no requirement that they'll be Muslim, Mullah. That's the point.
Let us read the category one by one.
Yes.
Where the Muslims are
union minister, Mullah, will not be Muslim.
Either a Muslim or not a Muslim.
No, it says, shall be non-Muslim. Excluding ex officio members.
Where does union minister in charge of work? A chairperson, ex officio.
Maybe, may not.
Either a Muslim may or may not be Muslim.
But that's their choice, Mullah. The point I'm making is that's their choice.
The cabinet doesn't remain same for the entirety.
No. That's not true in any other enactment, any other Hindu endowment, Mullah.
So that will examine. You are saying that by this composition, the majority would be non.
Theoretically. I'm not saying.
Let us examine.
That's right. That's what I'm saying. Now, let's assume that they'll be non-Muslims. Why your lordship is assuming that?
Let us say union minister in charge of work, a non-Muslim.
Non-Muslim. 1 Mullah. 3 members of parliament, non-Muslim. 4.
No. Where does it say?
Maybe may not be, Mullah.
Maybe may not be.
So I am assuming, Mullah, they may not. I am theoretically.
Let us see which are ex officio and which are not ex officio.
Correct.
So there are 2 ex officio.
Correct.
One is
joint secretary.
One is J and one is G.
Correct.
1 and 2. Assuming that there are 2, both of them are non-Muslims.
Yes, we'll assume that.
Yeah. Then under the proviso,
yes,
excepting ex officio, there can be 2 members.
No. 2 must be, Mullah.
Better we will call upon you when your turn comes. Don't show the enthusiasm as
Mullah, just
Priyankal is showing that side.
I will make sure that I don't remind you of anything while you're.
Let us read it further. Yes. Therefore, 3 members of parliament, of whom 2 shall be from the house of the people and
Correct.
from the.
They may be non-Muslim.
They may not be.
That's 3. Yeah. That's 3.
No, not 3. Provided that the 2 members, 2 of the members appointed under
House and 1 from Council of States, so 3.
No, it doesn't say. See, provided further that 2 members appointed under this subsection, excluding ex-members, shall be non-Muslim.
Just
so it doesn't say at least
Kindly see,
Or-
previous provision said 3 members of parliament shall be from amongst Muslims. In the footnote.
So B could be Muslim, non-Muslims also.
That's what I am saying, but he can be non-Muslim. I am not saying.
So let us see where there is a possibility of non-Muslims being there.
Therefore, the possibility is 1 chairperson, 1, and 3 members of parliament. Possibility of being non-Muslim, that's 4.
Yes.
Correct, Malaj?
Then-
Now you come to
Then
the Muslims.
3 is all Muslims.
3 plus chairperson of 3 boards by rotation, so 1, 4. 3 and 1, 4, Malaj, by rotation.
Then 1 person.
Then 1 person to represent Mutawalli is 5.
5.
3 persons who are eminent scholars in Muslim law, 8.
8.
Correct? Now, correct. So therefore, 8 maximum Muslims. Right?
No,
Now,
minimum.
8 minimum.
8 minimum Muslims. Correct. When I am assuming that all the others are non-Muslim, that's how I'm arguing.
So 8 minimum.
8 minimum.
8
Now,
are guaranteed.
Guarantee. Well,
Guaranteed.
that's the only guarantee we have in this statute. No ambiguity.
So-
Then 2 persons who have been judges of the Supreme
No,
Court.
so B could be either Muslims or non-Muslims.
Earlier they were all Muslims.
I agree. I am not disputing there could be Muslims. I am saying we are assuming now that they can appoint non-Muslims, that they are not prohibited to appoint.
No, but let us see. So that 3, then
3 plus 1, 4, Malaj. Chairperson plus 3 members of parliament, 4.
let us exclude chairpersons and the secretary.
That's 4, Malaj. Then you come to 4 persons of national eminence. That's 8.
Two persons who have been judges of the Supreme Court or High Court.
Yes, that's 2. Non-Muslims can be.
Non-Muslims.
So therefore, 4 plus 2, 6.
Yes.
Then 1 advocate of national, that's 7. And then 4 persons of national level, that's 11. That's what I was telling your lordship. And additional secretary, 12. That's what I was saying to your lordship.
Provided that 2 of the members appointed under subsection C shall be women.
Correct?
Now let us see, provided further that 2 members appointed under this subsection, excluding ex-officio members,
Shall be non-Muslim. Correct?
So the number is restricted to 2. It doesn't say at least 2 or it says there are 2 or more.
It's not limited to 2, but that's the minimum, Maharaj. The maximum we can have a guaranteed ones are 3 plus 1 plus 1 plus 3. 8. That's all. Theoretical. I'm not saying that they will not be Muslim.
The second proviso, the word used is 2. It doesn't say at least 2.
Excluding, Maharaj. Excluding the ex.
It says excluding 2. So at the most, if this 2 plus 2 ex-officio, it will be 4.
That's correct. That's correct. But they may not all be Muslims, Maharaj. See the previous section in the note, Maharaj. What it was. It's best we appreciate that, Maharaj. Compare it. Let's compare it. Excluding yes.
The same people will make money. It's a preceding thing.
Yeah. All of these were read in the line. I'm going to say, don't let them.
Keep it again.
Now see whether the previous provision in the footnote. Now it will make it clear, Malas. The council shall consist of union minister in charge, ex officio. The following members to be appointed by the central government from amongst Muslims. So therefore, 3 are Muslims, 4 are Muslims, 3 are members of parliament Muslims.
Right, when you say that all these have to be earlier. Now, the only distinction which has been brought about is that there can be 4 people, 2 ex officio and 2 further people. That's the only.
No, Malaj. No, your members of parliament need not be.
Therefore, maximum I'm saying 4.
There can be 12 non-Muslims because members of parliament need not be Muslim, Malaj. To proviso, it doesn't say that the rest of them will be Muslims.
Proviso also does not say.
Yeah.
Because it is restricting non-Muslims.
I'll let for a moment assume, Malaj, what the observation that's fallen from your lordship is right. I'll assume that, Malaj. I'll assume that for the moment. If it is right, Malaj, then what it means is that they can have at least 4 persons that are non-Muslims.
Yes.
That's what my lord is putting to me. Now, it's a departure from what? from the previous law where everybody had to be a Muslim? Correct, Mullah?
Except the ex-officio chairman.
Yes, exactly. Except that one, everybody had to be Muslim. So they have departed from that entire regime. And your lordships are now interpreting to mean that other than these two, everybody else will be a Muslim apart from the other two.
So because your argument primarily was that the majority would be.
I see. Could be. That's, I still maintain that, Mullah. Could be. Unless your lordships were to interpret that in such a way that everybody else has to be a Muslim, which is not reflected in the statute.
No, because the board uses second proviso, provided further that 2 members appointed under the subsection excluding ex-officio members shall be non-Muslim.
Correct.
So if the word 2 members would have been preceded by at least, then there might have been substance in your contention that at least 2 and it can be up to all those. But it says only,
all right,
it specifies the word 2.
All right, well, let me assume that. That's against myself for a moment. Let me assume.
We can interpret it in such a manner that
that's fair.
There can't be more than two members except the ex-officio from the non-Muslim category.
Correct. Anyway, according to me, 2 is too many also. But the reason why I'm saying this is
that 2 is not too many in 22.
Every
2 is not too many in 22.
Every religious endowment, Hindu endowment, does not have one person who is a non-Hindu.
Yes. Scholar. You know the Quran.
Not one person.
You must be aware about the debate going on about Bodh Gaya.
But that Bodh Gaya is Hindus and Buddhists, both.
They are only Hindus.
Both. The place of worship is for both. Act itself says that. I knew that example would come, Mullah. The Act itself says that. But that's the only exception, but the Act itself says it. In all other Hindu endowments, there cannot be a non-Hindu. Same for Sikhs, Mullahs. Gurdwara Prabandhak Committee. Nobody can be who's a non-Sikh can be part of it. So why this exception? Assuming, Mullahs, that we interpret the section in a manner that only 4 will be non-Muslim. We'll assume that. But why should there be 4? Why should they be there at all? If you're giving that privilege to other religious communities, why are you not giving that?
That's a different argument.
I'm putting it like
that. It's a different argument also.
No, I'm saying on interpretation, I believe, but anyway, that your lordships can do it after the final hearing. At the moment, my request is nothing should be done till your lordship hears all these matters, Mullahs. Now, it's even worse, Mullahs, as far as the board is concerned. Now come to 14. Bodh Gaya Act in 11.1, it says Buddhists of every sect shall have, notwithstanding anything contained in this act or the rules framed thereunder, Hindus and Buddhists of every sect shall have access to the temple.
It's a place of worship of two.
Because it's a place of worship of 2 communities, both Buddhists and not only Buddhists.
And the composition is here only either Hindu or Buddhist.
No non-Hindu or no non-Buddhist can go there even. So, Maharaj, that's the scheme of a secular nation where you allow the community representation within the construct in terms of which the...
What are the functions of the council, by the way?
Sorry?
What are the functions and duties of the council?
Advisory functions. Advisory functions.
Are they given a role to
yes.
interfere in the management of the particular work?
Yeah, your lordships will see. Advising the central government and boards on matters concerning working of boards and due administration of Waqf. Both. That's section 9, subsection 1.
So, section 5.
Yes, I'm going to.
Any dispute?
They can issue directives, Malad.
So, advisory on matters concerning the working of boards.
And Malad.
And the due administration of work. So,
administration of the Waqf.
They can only give advice.
No, administration also. 1A, see 1A, Malad.
Advice with regarding to the administration.
Just see 1A, Malad. The council, 918, council referred to in sub shall issue directives to the boards on such issues and in such matter as provided in subsection 4 and 5. Directives also. And what is 4 and 5? State government shall furnish information to the council on performance of Waqf boards. It's a direct interference in the administration of the board.
I will go to the Chief Justice.
And any dispute arising out of the directive shall be referred to a board of adjudication to be constituted by the central government to be presided over by a retired judge of the Supreme Court.
Substantive dispute.
So, Maharaj, these are huge powers vested in the council.
We will call upon them.
That's right. So now, come to now 14 Maharaj. Now, Maharaj, if you look at 14, all of them are nominated. No election. So all of them, in fact, boards are the entities. Board is the entity which actually administers, and all of them are nominated. Right. I don't have to read the section, but it's exactly the same as the council, Maharaj. The same provision. But except that these are all nominated. Now, let's. That's all right, but they've been nominated Muslims. No, that's what I'm trying to say.
Nominated earlier it said has to have been.
I'm trying to say that only. You are insisting on something. Earlier it was elected, now it's nominated. That's all I'm trying to say.
Here there is only one ex officio.
That's right. That's correct. Only joint secretary to the state government. But all this is nominated. Now, let's see the previous section. That is at page 20, Maharaj, and the note. The board or the state, for a state and the national capital territory of Delhi shall consist of a chairperson, one or not more than two members as the state government may think fit to be elected from each of the electoral colleges, consisting of Muslim members of parliament. So even members of parliament will have to be Muslim from the state, or, as the case may be, by the national capital territory of Delhi, Muslim members of the state legislature, Muslim members of the Bar Council, provided that in case there is no Muslim member of the Bar Council or the Union Territory, state government or the Union Territory may nominate any senior Muslim advocate, mutawallis of Waqfs having an annual income of so-and-so. So, and one person from amongst Muslims who has professional experience in town planning, one person each amongst Muslims to be nominated by the state government from recognized scholars in Shia and Sunni Islamic theology, one person from amongst Muslims to be nominated by the state government from amongst the officers.
So this election is only restricted only to one or two?
Two.
One or two.
One.
So it can be minimum one or maximum two to be elected from four categories.
Number of elected members shall at all times be more than the nominated members of the board. Right, Mulad? Page 20, at the bottom of 21. Clause 4, Mulad. Earlier clause 4. At the bottom. Last clause.
Page 20.
Page 21. Yeah. Footnote. The number of elected members of the board shall at all times be more than the nominated members of the board, except as provided in subsection 3. And you see here, Mulad, one or more one and not more than two members of the state government may think fit to be elected from each of the electoral.
Yeah.
That's correct.
So there could be one or two either from members of parliament.
That's right.
Then one or two from the members of the state legislature.
Correct.
And a bar council.
Yeah.
And mutawali.
Correct. So the point is, Mulad, one, you start nominating the board, which is the central authority, which administers Waqfs. You nominate your own people.
So the power is not with the central government, power is with the state.
State, Mulad, yes. Yes, the government, Mulad. This power is the government, Mulad, either way.
State government.
Yes. Absolutely right. So that takes care of 9 to 14, Mulad. The very scheme of it suggests, Mulad, that you want to exclude us from every facet of activity in relation to the Waqf. So we are here now, Mulad. Anything else? Yes, just so that your lordships may note it, I've given at page 11 of my note, the spiral bound note, I've given Religious Endowment Acts Just come to page 11. Even ex officio members have to be Hindus there, Malad. There can be no exception. But both the I see you as I mentioned earlier.
53.
Page 11, if your lordship notices, Malad. So, do you want to take a minute? You want to take a minute?
Maybe.
Okay. You will, lordships have page 11 of my note. You will see there Religious Endowment Acts, Andhra Pradesh Act, Tamil Nadu Act, Uttar Pradesh Kashi Vishwanath Temple Act. It starts from page 8. The annexure of it is at page 19, Malad, of these acts. So all of them, even the ex officio member, have to be Hindus. The idea is, Malad, it's not about discrimination. Idea is this is part of my right to manage the affairs of the community. So it's part of 25 and 26. And that is all subject to health, public order, and morality. None of this relates to that. Your lordship knows it says subject to public health, morality, and public order. What has this got to do with it? So just as educational institutions administer their affairs, religious communities administer their affairs. The Hindus do it, the Sikhs do it. Well, why should the Muslims not do it? Christians do it. And this is not secular. These are mosques, these are activities that are directly, the very creation of the Waqf is not a secular act. The creation of a Waqf is not a secular act. It's the Muslim's property which he gives away and dedicates to God. Somebody else can do the one. You want to do the data, this thing? Huh? This 116%.
I've got other data.
Okay.
5, 10 minutes.
That's no problem, no problem. Malad, I'm sorry.
I'm not
going to. Malad, just one last thing. They have made a submission, Malad, that after Malad's this amendment, in 2013, there has been a 116% increase in the registration of Waqfs. And the idea being that how can it be between 2013, there's a 116% increase. Right, Malad? Now we have an answer to that. They have not put it in their written submissions. Now you will deal with it? So my learned friend can deal with it. And Malad, Dr. Dhawan wants to take a minute, no?
No, just a minute.
Just 1 minute, okay. And then you can do it.
I'll just take it.
Okay. I'm deeply obliged to you, Lordship.
Right.
Just 1 minute.
Yes, Doctor.
My lord, by straining my voice, I might strain your lordship's ears, my lord.
Sorry, we can put up the mic here.
My lord, traditionally when we joined the bar, there were no microphones. We were taught to address the bar in full throat, my lord. Anyway, just 3 sections that I want to bring to your lordship's notice, my lord.
Now also, when Mr. Ranjit Kumar argues in the adjoining court, we can hear him. In this.
My lord, he's in a class by himself, my lord.
For someone else. Lord, during COVID, when we were appearing virtually, somebody said that, Mr. So-and-so, you are on mute. And I said, even on mute, he is heard.
My lord, just 2, 3 sections, my lord, and then I will conclude, my lord. My lord, kindly turn to your lordship's book.
Yes, yes, to make an atmosphere light.
Justice Kuldeep Singh and Justice Verma were the other 2 courts, Lord. And the summer, the doors were open, so they were missing from inside also, health inside. So of course, there was no mic those days, 1996, 97. Both those folks could hear my voice. They had to close their doors and the students.
Well, there is a real life story. Mr. Dhawan, Dr. Dhawan would be aware. Lord, once Winston Churchill was sitting in his chamber in the parliament. And in parliament, it is believed, my lord, in those days, that in the lobby there used to be telephones to be used by the members of parliament to talk to their constituents in their constituency. And somebody was speaking very loudly. So Churchill asked him that, who is this man and why is he shouting? His PS said that he is talking to somebody in his constituency. Churchill said, ask him to use the telephone.
My lord, my anecdote is, I told Justice Ramanna, as he then was, that I don't suffer from blood pressure. So he said, you give other people blood pressure, that's the reason why. But at any rate, my lord, levity apart, my lord, may I take your lordships to section 104, my lord, which is on page 76
Of the new act.
of the new act. Yeah, no, page 76, yeah. I will, sorry. Now, my lord, your lordships will see the title is Application of Act to Properties Given or Donated by Persons Not Professing Islam for the Support of Certain Waqf. Now, kindly see, my lord, the original act that your lordships will see on the next page in a footnote. Permit me to read it, my lord. Notwithstanding anything contained in this act, where any movable or immovable property has been given or donated by any person not professing Islam for the support of a waqf, being a mosque, idgah, imambada, dargah, khanqa, maqbara, Muslim graveyard, choultry, or muzaffar, then such property shall be deemed to be comprised in that waqf and be dealt with in the same manner as to the waqf, as the waqf in which it is composed. I'll make a point on this in a moment, my lord. Then kindly turn to section 23, my lord. I'll just read, my lord, Now, if your lordships will see that it says there shall be a full-time chief executive officer of the board to be appointed by the state government who shall be not below the rank of so-and-so. Now, my lord, kindly see the original section. There shall be, at the bottom of that page, my lord, there shall be a full-time chief executive officer of the board who shall be a Muslim. I won't read the rest, my lord. There are at least 12 sections of this act which deal with the powers, duties, and responsibilities of the chief executive officer. One more section and I'll make one or two points, my lord. Now, my lord, kindly come to section 2. This your lordships will find on page 5. Your lordships will see that a proviso has been added. Provided further that nothing in this act shall, notwithstanding any judgment, decree, or order of any court, retrospective, apply to a trust by whatever name called, established before or after the commencement of this act, or statutorily regulated by any statutory provision pertaining to public charities by a Muslim for a purpose similar to a waqf under the law for the time being in force. My lord, I won't elaborate other than judgment after judgment of your lordships, my lord, have indicated that a waqf can be in the form of a trust. And eventually, earlier, my lord, the board decided whether it was to be a trust or whether it was to be a waqf. Now, this was a very important provision, my lord, right from Ratilal, the first decisions of your lordship, 7-judge bench. There has never been any doubt that if your objectives were in the form of a trust, similar, and those are the words used here, my lord, similar to those of a waqf, this will entirely and completely disappear. Now I will make, my lord, 2 very general points.
I didn't get you.
My lord, earlier, supposing I am a waqif, my lord, and I create a trust which has objects similar to that of a waqf, it would be in the past treated as a waqf. Now, my lord, many, my lord, waqifs put their objectives, ultimately, remember, my lord, it's the object of charity, object of religion. Now, if the object of the trust is similar to that of a waqf, and there were a large number of them across the board, my lord. Ratilal, my lord, is a case from Bombay. It dealt with the charity commissioners, and the issue once there was whether the charity commissioners would have control or whether the Waqf board would. And your lordships ruled that if it is similar to a waqf, then, my lord, it is not the charity commissioners who will appoint, my lord, the custodian.
But the board.
With the board. Or the board as it then stood, my lord. Now, this is an important takeaway, my lord, because a large number of waqfs are in the form of a trust. What this does is, what was earlier a matter of form has now been removed as a matter of substance. Just 3 points on that, my lord, and 2 additional points I want to make.
What you are trying to say is basically that any trust would not be a waqf anymore.
That's right, my lord. Even if it is similar, even if it is, my lord, trusts are in their own area.
That's right.
There is a distinction between the two. Yes. But if it is similar to the nature of a waqf, it would be treated as a waqf.
Correct.
And there are a large number of such throughout India. Now, my lord, I have 2 more points to make, my lord. My lord, Mr. Sibal has already indicated, and this has never happened, my lord, in the past, of the redefinition of a religion and religious property. Never before, my lord. We go back to the Board of Revenue of 1810, my lord, of the East India Company. They didn't change the nature of the Waqf property. Neither 1817 in Madras, nor in the 1923 Act, my lord, nor in the 1994 Act, nor in the 1995. What was the occasion, my lord, for this large-scale liquidation of the very concept of Waqf? My lord, no religion in the world can survive apart from belief, practice, property. You take that away and no religion will have any longevity at all. So this goes to the heart of every religion, and it is only the Muslim religion where this property has been dealt with in this way. But that is not my only point, my lord. The important point is, my lord, it's an issue not just, my lord, as far as this is concerned. My lord, we are a secular nation. One of my clients, my lord, in the writ petitions, not listed before your lordships, happens to be a Sikh. He says, I want to contribute to Waqf. I believe that this property should not be taken away. This is an issue which goes fundamentally to the question of secularism, Lord. Because Article 25 and 26, and I would add Article 29, the preservation of one's culture. That's right.
Article?
Lord, 29 as well, which is the right to preserve your culture. How would you preserve it, my lord? You preserve it on the basis of your beliefs. You preserve it on the basis of your practices and on the basis of the property that sustains these beliefs and practices. Take that away, my lord, the entire secular edifice which your lordships, my lord, have built from time to time and time again, my lord, will also become suspect. I have one last point, my lord. Mr. Sibal has dealt with, my lord, classification, manifest arbitrariness. My lord, when you justify these changes, what is your justification? What your lordships, my lord, have laid down is the doctrine of proportionality. Where is the proportionality? Now they, on the other hand, says there is better effective management. At one stage in the counter, they say certain persons were not registering as Waqf by user. So, my lord, the question that your lordship might put to them is, you want to achieve certain goals. It has to have a nexus that's established. Where is the proportionality behind the changes that you are now making in relation to the objectives to be achieved? And my lord, across the board, no justification has been given as far as proportionality is concerned. My lord, I adopt the rest of the arguments.
It was a pleasure hearing you after a long time.
I know, my lord. Even in my throaty voice. My lord, there's one small point, my lord. This act is in the teeth of a large number of constitution bench decisions of your lordship. Charity, Ratilal, Babri Masjid, my lord, para 1131, which says Waqf by user is a part of Islam. So it's in the teeth of a number of constitutional. Now, my lord, your lordship interpreted in TMA Pi the meaning of the word establish and administer.
It's 1134 paragraph.
1134. That is in M. Sadiq, my lord, the Babri Masjid case.
2021 SCC, page 1.
So, my lord, now, my lord, the question as to whether educational establishments also came in TMA Pi, in para 25 and 26 of TMA Pi. The phrase is establish and administer. I have a right to establish, my lord, under 26B of the Constitution. I have a right to administer. Those rights, it is stated way back in 1954, no legislature can ever take them away. That's all. I'm very deeply obliged.
Very pleased, Your Lord. So I will finish even before possibly the end. Very pointed.
Bear down your.
It's difficult to navigate what is left over, and I'll try to just give you lots of points without repeating.
Let's all shift.
Incidentally, well, it's the first learned judge who could be heard holding his own court in Supreme Court and other courts came from my state. And the second learned judge,
of course,
there were two learned judges, Malas, who could be heard in other courts.
Yes.
One from Rajasthan in the old days, and then one from Mumbai. Justice Tulsapurkar, Justice Bhargav, who was the uncle of Justice Suresh Agarwal. They are the two learned judges. You could clearly hear them in those days. Anyway, now, Malas, the first point, and I'll make it only point for Malas. 3R, your lordship has seen. Just pick up 3 small r for a second. Now, 2 points have already been made in the text of it. This is page 7 of the Act, perhaps. The 2 elements there are, one, proof of your practicing Islam. And the second is this delightful word, contrivance. So the first thing is, Wallace, that you can never apply, look at the word, Wallace, and that there is no contrivance involved. It's a recipe for making the applicant visit the offices of the collector or the officer for eternity, trying to prove that there is no contrivance involved. It's the most vaguest, arbitrary, completely whimsical word used to invite terror, control, and endless business to the government office. Second, people of all religions make religious endowments. All. And India is, planet Earth's most diverse spot. Which other religion, at the point of making a religious endowment, by whatever name called, is asked for proof of that religion's professing and practicing? For 1 year, forget 5 years. For 5 years, for 10 years. Which religion? Point number 2. Point number 3. That brings in directly an article not really directly mentioned, Article 15. This provision goes on the short ground subject to my Lord's discretion of violating Article 15. Textually, it is a discrimination on ground of religion. Religion X and its donors and its creators of religious endowments are asked for proof of their religion, which is directly contrary to Article 15, which Lordship knows very well, Mills. Out of 7 or 6 tests, the first word is religion in 15.1. The state shall not discriminate against any citizen on grounds only of religion, comma, and this is only religious, race, caste, sex, place of birth, or any of them. Religion is the first. And it is singular, in its novelty. The state is discriminating by using Parliament to pass a law, and therefore that law is unconstitutional. My second point relates to the Waqf by user point and goes slightly beyond. It has already been made, I only want to fill up a gap. By its very nature, Waqf by users were largely unregistered. At some point of time, a requirement came to give particulars and register, be there aside for a minute. The subpoint in 3C and all the other provisions there is the access to court point, the remedialist point. Now, my learned friend has already shown to your lordships the arc which connects 3C, 36.7, 36.7a, and 36.10. That must be kept in mind. And a vicious circle that once you cease to be Waqf, you cannot exercise the remedy, principally because you're not a Waqf. So it's trying to catch your tail. The ground.
Please repeat yourself.
This arc is very interesting. Just let us pick up 36. 3C, my lord has seen, dispute. The counterpart of 3C is found in 36.7a. My lord has noted that. There also a dispute means you're not a Waqf. So one principle is in this act. The moment there is a dispute, a Waqf, so-called a Waqf established, a Waqf 500 years old, ceases to be a Waqf.
That's what...
Both 3C and 36.7a.
That's what Mr. Sibal also.
Yes, but I am not on that. I am now on the access to justice. I am slightly. Now, the moment you cease to be a Waqf, there is no question of registration or unregistered Waqf moving a court. And the bar of 36.10 applies in full force. That's why my Lord Bernard read your worship 36.10. So I say it makes a vicious circle that any dispute, and the dispute can start tomorrow. It doesn't have to be a pre-existing dispute. It doesn't have to be a dispute leading to a decree or an appellate decree or a Supreme Court decree or prior to this date. It can be a dispute started tomorrow. I can start a dispute tomorrow. So that is clearly exclusionary. Now, what I'm going is one step further. I heard an interruption saying the 36.10 was always there. That is more than a half truth. Please note what was the 36.10 predecessor. Give this note. Come on quickly. This is not a note for reading, but it's just for the quotation I've given you, so it'll be easier. Please ignore all the text. I'm not giving it to the side.
Note at the end. I know you just
can I read a provision of statute from a note?
Read the provision.
Yes. Mr. Mehta, I hope that's not your best point, Mr. Mehta.
No, that's right.
Now let's come to page. Kindly come to page 4. Till now, I have not read the note, but I'm in terror. I'm reading only the provision from the note. Para 7. Now, this is important. Well, let's just don't read it for a minute, give me a reference. In the 1984 Act, there was a bar of initiation of proceedings.
You're reading paragraph?
Well, it's 7, at page 4 of this note. Just the quotation, I'm using it for once. Does that not have it? See the underlined portion. Unless such Waqf has been registered. Right, brothers? Now your Lordship will note the next line. The amendment was not brought into effect is an admission and a fair statement by Mr. Mehta at page 36 of his counter, para 55. That italicized statement by me is a quotation from Mr. Mehta's counter, page 36, para 55. I hope I'm clear, brothers. So, broad ouster clause was never brought into effect according to the counter. Now, the next provision quoted is a provision in the 95 Act called Section 87. I hope there's a misprint there, that section should be 87. If there's a misprint,
that is correct.
Corrected. I'm grateful. Now, this is another, the wordings are not identical. We are not concerned with that. Again, another kind of ouster. See the underlined portion, unless such Waqf has been registered. Right, fellas? This was deleted by the 2013 amendment. That's why I said it's more than a half truth, fellas. From 2013, this deletion stands. This vicious circle of connecting 3C, 36.7, 36.7a, and 36.10 starts only with this 2025 regime. I hope I am clear on my second point. My third point is, about that ancient monuments, where Mr. Ahmadi has made a very comprehensive note, which I will not go into. Yes.
This side will have to conclude by 4 o'clock.
I will conclude in
We have already granted more than.
Yes. I have started at 3:35. I'll conclude.
No, we don't know.
Well before that, I'll conclude.
Well, we had said 2 hours, but we are again more. If we continue till 4 o'clock, we will be giving more than 3.5 hours.
I will conclude, my Lordship may not doubt that at all. 100%. Even if I don't conclude, I shall conclude once.
No, the others are in waiting. So
yes.
Everybody would like to.
Now, let me just say what I wanted to say on this, just for a minute. On 3D, if something is left, I'll try and leave it.
No, not more than 4.
Let's finish. Let's use the time we have.
Yes. Since 20 minutes are left, we thought that Dr. Singh would be generous for others.
My lord, 4 minutes for me, my lord, because I have.
This will take away my 20 minutes. So let me finish as soon as I can.
After that, my lord, finish. My lord will consider that.
Now, the 3D, number 1, 3D, all the other facets of 3D I'm not repeating. That has been argued. 3 capital D. It would, read as it is being read by the government, would even circumvent and impinge upon the Place of Worship Act, 1992. Clearly. Your Lordship reading it differently is something else. I'm not concerned about how Lordship read that, of course, can be protected. Lordships can read it. As textually framed and as argued, this non-obstant situation in 3D, superimposing Ancient Act, Monuments Act onto this, superimposing 2025 Act on the Ancient Monuments Act, has a direct result of affecting even those protected by another special act called the Place of Worship Act 92. Effect of the Places of Worship Act 1991. I'm sorry, 1. Because something, let us say, a character of a place of worship which is X religion, Y religion, Z religion, is shut off on a cut-off date. Today, by a notification here, for example, for Muslim places of worship, you will create a situation where at least your lordship will have to work it out. Otherwise, on a literal interpretation, it will override that. The second point on that is...
So work out what? Work out what? You said that you will have to work out.
No, your lordship, unless absent your lordship's interpretation that the Place of Worship Act protection on a cut-off date remains a Muslim place of worship, a place of worship.
Ancient monuments.
I am arguing Place of Worship Act. I am not arguing Ancient Monument. I am saying if you notify under the Ancient Monuments Act.
According to him, by superimposing
yes.
the Ancient Monuments Act on the by 2005
the declaration under D
also affects the rights available to the citizens under the right to worship
yes.
1991.
It's not even an argument to be dealt with. I'll deal with it.
It is my argument, not your argument. Because you haven't.
Is it a pleading?
Yes, it is a pleading. It is a pleading. We'll give that also. Take it out. It is a pleading.
In fact,
because
that overrides all other laws.
A Malad's monument, which is a monument which is protected under the Place of Worship Act, can be declared under a notification under 3D. That is the point I am making.
3D, there is no notification.
3D opens the word notification. Allow me to have my 15-20 minutes. Let me have my fundamental right to say wrong things.
15-20 minutes?
No.
You decide about yourself.
He is not allowing me my fundamental right to say wrong things, Your Lordship. What do I do?
So then,
he is interrupting me every sentence.
We don't mind, but then we will not be after
I'm trying to finish. The next point here is Article 15 comes in again. Because on 3D, Your Lordship has chosen one religion in this act. Not Your Lordship, the act has chosen. One religion.
So this act itself is applicable to one religion.
That's right. Now this this act applying this interpretation of the Ancient Monuments Act to one religion is what hits Article 15. That's my point. The fact that 3D textually applies the Monuments Act on this act and this act on the Monuments Act is only for one religion. That's Article 15, Manas. Your Lordship is considering prima facie constitutionality and whether to give Manas some interim orders. Therefore, this is very relevant.
Yes.
Now, Manas, this is as far as 3R and 3D is concerned. Lordship may also note that Your Lordship knows the law very well, that Your Lordship doesn't normally grant a stay. But look at the language Your Lordship used in the Farm Acts case, brothers. Kindly hand over that case. Bernard, give that case. Rakesh, give it quickly. 2021, 1 SCC 590. Rakesh Vaishnav, about giving us, we are not asking for a stay on the whole act. We are talking of the provision Lordship has heard us on. All these provisions. My Lord has said this about the whole act. Kindly hand it over.
This was an unopposed order. We conceded. Let us you be clear and honest about it. Justice Bobde's order, Madam.
I can't be clear and honest about anything before opening the book and reading the case. Kindly turn to us. Para. Give me that book. Give me this one. Yeah. Wait, you don't. Just give me 1 second, brothers. Para 10, 11 and 14. If my Lord comes to 10, let us see what the Attorney General said, and let us see that the last interruption of Mr. Mehta was right or wrong. Please turn to para 9. Para 9. It starts at when we put across above suggestions. Got it, Your Lordship, got that? Para 9 starts like that. The learned Attorney General, even while agreeing for the Constitutional Committee, vehemently opposed the grant of any stay of the implementation of farm laws. I don't know what that English language means. Next page, continuation para. The learned Attorney General contended that the court should not stay the implementation of the laws. That was para 10. though we appreciate the aforesaid submission of learned Attorney General, this court cannot be said to be completely powerless to grant a stay of any executive action under statutory enactment. Even very recently, Jayashree Lakshman Rao Patil. Now come to 14. I agree, Mother, your lordship has granted for the asking. But if there is one act, one statute, one case which Mother cries out for certain absolutely sinister provisions requiring to be said, this is it. Having heard the different perspectives, we deem it fit to pass the following interim order with the hope and expected both parties will take the right spirit attempt to arrive at a fair, equitable, just solution. The implementation of the 3 farm laws, all the laws are listed, last line, shall stand stayed until further orders. As a consequence, the minimum support price in existence before the act shall be maintained. We are asking for much, much, much lesser ones. We are asking for much lesser. Then, Mothers, your lordship's recent judgment on 300A, authored by Justice Gawai, Chief Justice Gawai Mothers, just a few weeks ago. I'm not saying that Mothers is all, just note the citation. 300A.
The Karnataka matter?
Yes, Mothers. Called Mothers Bernard Vaz. 2025 SCC Online SC20. Don't read it, just bear with me, Mothers. Kindly note the citation. Court Master will do it. Paras are 42, 43 and 56. The important point is that your lordships could have decided on the Karnataka statute about delayed compensation. My lords made it a point in para 42, 43 and 56 to say that what must imbue your lordship's interpretive approach must be 300 capital A. Namely, how you will interpret a provision, what will be the effect of that interpretation if it is expropriatory, and we have shown in detail what is expropriatory. I don't have time to repeat that. It will be imbued by what your lordship calls in those paras 42, 43 and 56. It's not a mere statutory right. It's a constitutional right. It may not be a fundamental right, but it's much higher than a statutory right. That's what your lordship says. So kindly note these 3 paras, 42, 43 and 56. Okay, your lordship has got this thing about increase of trust by 100%, etc. properties. Just note this, fellows.
42, 43 and
56. Where is that? Well, it is said, one of the arguments in the counter is that there is a huge surge in Waqf properties. Suddenly, a huge surge, explosion in numbers. Just note the answers were ABCD. A, the loading on a portal which they've created for listing Waqfs started in 2013. The loading onto the portal. That is pointed out in my rejoinder at page 5. Lordship may just note it for saving time. Therefore, as the portal was populated over time, the numbers had to increase. Before that, you had no population on that portal. They are treating an increase in the portal population of listing as an increase in Waqfs. An updation exercise. Number 2, the learned Minister of Minority Affairs on 18th of July 2019 at the rejoinder page 60 of Mr. Ayubi's file. Mr. Ayubi's writ at page 60 has the answer to an unstarred question. He says we have increased now and are proceeding day to day on increasing digitization. So what is being prejudicially suggested to your lordships to increase numbers of Waqfs is actually an increase in the portalization and the digitization. Thirdly, there are many properties in a Waqf area sometimes. They were treated as one Waqf property. Now each is listed separately. This is all stated in my rejoinder. So let us not have these prejudicial arguments in the counter that there is again and again a lot of prejudicial arguments are given. That you must have more and more, you are having an explosion. Your lordship should be aware in this note. Just turn to one fact. All we are talking in the abstract about registration and non-registration. In this note at page 2, extract from the JPC. Just see this for a minute, the note I gave. We are talking in the abstract about registration, non-registered, work by user, etc., etc. 2 figures only your lordship will note. This extract at page 2, 2 minutes more, 3 minutes more. For the state of Bihar, now the Bihar Waqf Board filed a document before the JPC. It's only extract from there. It is an annexure to the JPC, it's extract from there. Out of 20,000 mosques, only 5.98% are registered. Just note that one line. And
Note.
Second page, which is an extract. And the second line is, on 27,000 graveyards, 3.6% are registered. This is from the Bihar Waqf Board's written submission and annexure to the JPC report. And well, note my learned friend's counter with annexure at 195. That is Mr. Mehta's. Page 195. PDF page 197, please.
Zero.
He says 50% roughly are Waqf by user. The figure he gives is 8.72 lakh properties, of which 4.02 are Waqf by user. Only that one line also save time. His own counter, annexing as part of the JPC extracts, says that. But there are some more things, but I'll give it in a note if necessary. There's one last thing, and I'm getting but it's just these pages. References, Lordship, will not because I have time to see it. The reference I gave last was about the 195 of the counter where the annexure is given, which says out of 8 lakh, 50% are Waqf by user. Well, there's two more statistics and I'm done. Para 80 of Mr. Mehta's counter. Para 80. Para 80 of his counter says those Waqfs which have not been registered nor have they been found in existence during the survey by the Survey Commission, their claims are not maintainable at this belated stage. This is para 80 of his counter. The emphasis of the word survey by the Survey Commission. Well, as your Lordship will note, the JPC report at page 92 points out that survey is done only in 5 out of 28 states. It's a travesty. Just note the reference, page 92 of the JPC report. My friend's counter doesn't point this out. 5 out of 28 states and 4 out of 8 UTs. This covers JPC.
Just filed a note with new facts.
I have not filed a single note. I am quoting from your counter. Now let us go. I have quoted from your counter and the JPC report. Please don't misrepresent. Please don't misrepresent. Now, 9.3% of the area of the country as a whole is what these 5 states and 4 UTs represent. You do a survey in 9.3% of the area. In your counter, you say that in our survey, we found no registered Waqfs.
Not survey.
Your survey is only in 5 out of 28 states. And then you try to shut me out. I'm deeply obliged.
May I just take 2? I'd like to take 2 minutes. Just there's one aspect which your lordships.
I won't get a turn.
Your lordships were there's a point where there was some concern expressed by the court.
We don't detain you any time. We are not detaining you on a single day.
I have to seek a lot.
We quite appreciate your difficulty. You have to be at the right time before the other court.
Today, your lordships can't say that. Can't say that.
Lord, I just want to answer one aspect because your lord, several questions fell from my lords when my learned friend Mr. Sibal and Mr. Dr. Singh were arguing, was with regard to the mandatory registration requirement. So I just want to place the correct position with regard to that. Plus, there's a 1923 Musalman Waqf Act 1923. Is the first time, it's not registration, the first time a requirement came for declaration. Under section 3, a declaration was to be made to courts with regard to Waqf, and section 5 required some accounts to be maintained. In that act, the responsibility was of the Mutawali, and under section 10 of that act, the penalty, section 10 of the 1923 Act, my lord may just note, the penalty was 1,500 rupees. And for repeat offences, repeat subsequent offences, 2,000 rupees was the penalty. Section 10 of the 1923 Act. Section 3 is the obligation to furnish information by making a declaration to a court. Section 10, penalty on the mutawalli, was 500 rupees for the first offense, first conviction, and 2,000 rupees for all subsequent convictions under Section 10. Then comes the 1954 Act, which is the first post-constitutional act, which is the Waqf Act 1954. Chapter 4 provides for registration of Waqfs by the mutawallis. Section 41 of the 1954 Act provides for a penalty of rupees 1,000 for the first conviction for non-registration, and for subsequent convictions, if there is a subsequent conviction, the removal of the mutawalli under Section 43. The Waqf doesn't go, the mutawalli goes under that provision. Then comes the 1995 Act. And in the 1995 Act,
what is the provision in the 54 or 58 Act?
In the 1954 Act, Chapter 4 provides for registration of every Waqf by the mutawalli. Chapter 4 is Section 25 onwards. Section 41 provides for penalty of rupees 1,000 for the first conviction. And under Section 43, if he is convicted a second time, the mutawalli suffers removal without his rights as a beneficiary going, but as mutawalli he gets removed from the Waqf. That's the only consequence. Now, my lords, comes the 1995 Act, which is the present Act. 2025 is an amendment. Now, Section 36 in Chapter 5 provides for registration of Waqf from 1995 till today, till 2025. And Section 61 provides for penalties. The penalty in Section 61 for A to D, A is registration. The penalty for a violation of A to D is a fine of rupees 10,000. And for E, F, G, H, which are most grievous things, which don't have to do with registration, but with taking away properties, etc., is imprisonment for 6 months. Now, even today, even in the 2025 amendment, the penalty for non-registration has been just increased to 25,000 rupees on the mutawalli. Non-registration does not carry any other consequence except a penalty on the mutawalli. Even in the 2025, it's only a 25,000 rupee fine, which is imposed on him. So now please see the definition of beneficiary in 2A. My lord may just note it. This is a very unique situation right from the 1954 Act. The exact same definition of beneficiary is there. And in Waqfs alone, unlike other trusts, not just the people who benefit from it, but the objects are a beneficiary. So if my lord just sees the definition of beneficiary, and from 1954, 1995 and 2025, beneficiary means a person or object for whose benefit a Waqf is created and includes religious, pious and charitable objects and any other objects of public utility sanctioned by the Muslim law. The same definition, 1954, 1995, 2025. So the beneficiaries can't be made to suffer for the offense committed by a mutawalli. That is the whole point. The objects of the Waqf don't disappear. Because if the mutawalli has not gone and registered, or suppose there's some impediment on registration, he was not able to find the records, etc., or for whatever reason it's not registered, neither the objects can go, nor can the beneficiaries who are the who benefit from it can be deprived of that. And that is why, my lords, no law, including 2025, has a consequence of Waqf vanishing. Now, 2025, by the other provisions in 3C read with 36, 7A and 10.
7, 8 and 10.
Yes, there, the entire Waqf vanishes due to non-registration. That is why, my lords, it's very, very egregious, lords.
So can I start tomorrow at
Lordship, just hear him for 5 minutes. Just 5 minutes.
Just now, notes can be.
We had requested all of you to share your time with him.
No, just one thing. Our note, the spiral bound note, we had, as your lordship director, we had shared our points with Mr. Singhvi.
You give a consolidated note.
No, that is a consolidated note. So your lordship, read that note as our submissions.
This is spiral one is the consolidated note.
Yeah, please treat that as our submission.
My submission is the
Yes, yes.
consolidated
It contains submissions of everyone.
Yes, I have incorporated
We
my
do, in vacation, we don't want to just
it's not there.
use note and that.
I didn't argue those proportionality, all
But
those.
that may be read.
Commercially, Dr. Singh, we argued.
It's all in the notes, mother.
It's a consolidated note. Mr. Singh, note contains everyone's argument.
Mr. Izaz has prepared it. You are prepared.
Yes.
Look, my points are in that note. Your Lordship may
Just
kindly.
let him say a few words at least.
Let Mr. Ahmadi, my lord, give
Just a
him
few words,
2-3 minutes.
Okay, we'll give 5 more minutes. Yes.
That's all.
I leave it to your lordship, Malaz. I wanted to assist your lordship. If your lordship feels, Malaz, that
We know that you all of you have prepared, but
I don't want to say anything.
no, therefore we had requested Mr. Sibal the other day that please, your time is over. We will also not give more than tomorrow to the other side also. That they have to.
Exceed 2 hours is.
Whatever time we have given it to them, we'll give it to you.
I'm not followed on that.
Ordinarily, in the opening,
They
Malaz, council takes a
crossed
little longer.
much
to be
beyond
able
2 hours.
Because some facts are to be stated. Now, just very quickly, Malaz.
Yes, please.
May I just very quickly state a few points, Malaz? I have prepared a separate note.
No separate.
Separate.
Otherwise, you take this note back and give us a consolidated.
Very well. Then I will not go through that. Malaz, just 2 aspects that I want to highlight. Just, Malaz, have the act. If your lordship just has section 108 and section 107. The impact on evacuee properties is quite substantial. Now, 108 was already read to your lordship.
Dr.
Yes.
Dhawan read it.
Yes, ma'am. Now kindly see 107. Does your lordship have 107?
Yes.
On and from the commencement of the Waqf Amendment Act 2005, the Limitation Act 1963 shall apply to any proceedings in relation to any claim or interest pertaining to immovable property comprised in a Waqf. Coalesce it with section 108, which deletes evacuee property. Now, the effect of 107 and 108 together is that evacuee properties are out by virtue of section 108. So, therefore, a registered Waqf in relation to evacuee properties by virtue of deletion to section 108 gets obliterated. Now, today, my lords, by virtue of section 107, if I want to challenge any such declaration of evacuee property per se, that will be hit by limitation.
That will be hit by?
Limitation, because the Limitation Act applies. So those declarations, my lords, which are age-old, which were protected by virtue of section 108, that those Waqfs existed by virtue of section 108, because the number of evacuee properties which are declared as Waqfs are huge in number. Point number 1. Because for paucity of time, I am not elaborating those points. Point number 1. Point number 2, Malaz. So far as section 3D is concerned, 3 capital D. Malaz, I won't read 3D again, but your lordship recollects the text of 3D. What 3D says is that any property which is declared as an ancient monument and either under the Act of 1904 or under the Act of 1958, that declaration shall be void. Now, Marad, just contextually, the history has been explained. The Act of 1904 and the Act of 1958 has listed several properties, including, my lords, ancient mosques. Now, at the time, my lords, of the 54 Act, 23 Act, my lords, only applied, my lords, in respect of declarations. So, under the 23 Act, all that you have to do is seek a declaration before the court. That's for the first time that the provision for declaration came. The 54 Act, for the first time, my lords, made registrations compulsory because it says it shall be shall. Now, even if I have a registered Waqf, under the 54 Act which I have registered, under the 1995 Act registered of any nature, whether it is Waqf by user or otherwise, all of them get obliterated if on the date of the registration prior thereto, this was declared, my lords, as an ancient monument. So ipso facto, my lords, A, it is retrospective. And second is, my lords, by virtually by the sleight of a hand, my entire Waqfs, all of them which were registered earlier, my lords, completely gets obliterated by the operation, my lords, of section 3D. Now, the reason why, my lords, the argument, the submission, my lords, on Article 15 is extremely important is that there is no similar or analogous provision in any other act with relate to any other relation.
That is what Dr. Singhi also argued.
Correct.
Article 15.
That's correct. So, my lords, this only singles out one particular community. And, my lords, that also happens to 3E, because insofar as tribals, scheduled tribes are concerned, even, my lords, the very same provision, my lords, applies. So that's, my lords, the additional point that I wanted to make. The third aspect, my lords, of this particular of 3D is, your lordships, my lords, under an interim order have restrained any further suits which are impinged upon by the Places of Worship Act of 1992. Now, the effect of 3D is that even those ancient monuments, my lords, which are protected specifically by your lordships interim order, will all get resurrected, because the government today can say that so far as those particular places of worship are concerned, I will regulate the manner in which the practices are to take place. So today you may say you will not use it for any purpose whatsoever. By virtue of 3D, that is the effect of 3D. So that therefore, my lords, that's an overarching provision. Fourth point, my lords, just very briefly I'll make it. I made my point on evacuee property. I made my point on limitation. Just one more aspect, my lords. The expression practice of Islam for a period of 5 years. And, my lords, that aspect of contrivance.
5 years.
5 years. Now, my lords, firstly, the point has been made that, my lords, in any other endowment act today, if I want to endow a property for the purposes of for a temple, there is no restriction, my lords, that I have to prove that I am practicing that particular religion for a period of 1 year. That's point number one. The second aspect, my lords, is how will you determine this factually? Is there an ascertainable principle by which you can determine this aspect as to whether this person is a follower of Islam or not? For example, my lords, can someone ask me that do you pray namaz 5 times a day? Otherwise, I will not permit you to make an endowment. That's an essential feature of Islam. Suppose some other Muslim is asked, do you drink? Will that be a criteria, my lords, for the purposes of saying that don't have it? And so far as contrivance is concerned, my lords, suppose tomorrow, my lords, someone wants to make a particular endowment. How will you determine, my lords, whether that is contrived or that is not contrived? That's the third aspect. And lastly, my lords, what I want to say is that so far as government properties are concerned, the injunction comes into force merely, my lords, upon a dispute being raised. There is no real formal adjudication which is required for this particular purpose.
That is already elaborately.
So therefore, my lords, therefore, my lords, in sum, all that I'm saying is that so far as my lords 3D is concerned, its impact is drastic. My lords, it will apply to age-old mosques, age-old properties, and 3D, my lords, really requires an absolute stay for my respectful sir.
I appear in the 5th of the 5 lead matters. Only 4 have been. Lordship, I just have two points to make. That's all, Lordship. Not detailed submissions. 2 points which have not been made so far. Lordship, the first is.
Everybody says that, but then.
Lordship, and I'll keep my word, Lordship.
Lord, it's almost 3.5 hours. I'm not objecting, Lord.
No, 3 hours, 45 minutes.
Lordship, it's already been stated.
I have come from Srinagar, my lord, only for this matter because most of the property, Waqf property is there in Srinagar. Please give me.
Lordship,
you include your points in the
clarification is listed.
Lordship, it has already been.
2 minutes. I will make question clear as far as Waqf is concerned.
How much time your side? How many? Who are going to argue?
5, but I'll start, my lord, and I'll cover, my lord, substantially, but will not take more than what they've taken. You
can't. You should take lesser than that.
Yes, certainly.
So that we should give them some time for
points which were not brought to your lordship's notice, my lord, half sections, etc. I mean, I'll have to show, my lord, what is
Lordship,
the
I'll
real
just take a minute.
purpose, intent, object.
Lordship, that's a very important point. So, please.
I'm better.
Now, there is a Waqf board also. Well, interestingly, one of the state Waqf board is before your lordship supporting this. We'll point out, no? I'll point out.
Lordship, in a very quick minute, Lordship. Lordship, it's already been said that
that's the only good.
My lords may grant us tomorrow, Malad, because
no, sorry.
Malad, there are good, Malad, important points which I have taken in
Lordship, mine is the fifth matter out of the
just
matter.
3 minutes, Malad. I will not take more than 3 minutes.
We had requested all
Malad, on the religious
time in 2 hours.
In the
We have
context,
given you almost twice of that.
in the context of religious, if your lordship would consider my application, everything has been detailed, Malad, everything has been spelled out in time.
Lordship,
Lordship may kindly give us tomorrow, Malad, 5 minutes.
Please don't do this.
Lordship, 5 minutes, Malad.
So you give your notes.
Lordship, I appear in one of the lead matters which have already been selected as a matter that have to be heard. Lordship, I'll just take 2
We had
minutes.
requested you to fix up timings among yourself.
Lordship,
Instead of 2 hours, we have already granted you 3 hours 45 minutes.
Lordship, as the youngest member of the family, that's not something I control, Lordship. So I'm just asking for 2 minutes of my Lord indulgence to make points which have not been made so far.
2 minutes by the clock.
Why not 2
Very well.
minutes for me also?
Okay.
I shall be grateful. Grateful.
Okay, tell.
Lordship, I
Obliged.